You're on the record on State versus Madden, CR 22-121675. The jurors are not present. The defendant is present with counsel, Mr. Wilder, and Mr. Burris, Mr. Hahn, and Detective Horton are present on behalf of the state of Ohio. Before the jurors come in, is there anything to put on the record on behalf of the state?
There is not anything. I just need, if I can, I was going through the exhibits real quick.
Oh, sure. Okay.
Nothing on behalf of the state of Ohio.
Anything on your behalf, Mr. Wilder?
Not at this time.
Okay.
You just give me one
Sure.
second.
So a witness here?
I guess you're right. Yeah. You want to admit and understand?
That's good. I can do that.
Okay.
I haven't read it.
Turn it over.
Screen down.
Just go ahead and seat it for the time being. Good morning, ladies and gentlemen. I want to thank you again for coming in early today. Does anyone have any violations of the court's recess instructions that they need to report? Okay. All right. As you'll recall, we left in the middle of Detective Trenum's testimony. And Detective, I would remind you that you are still under oath. And Mr. Burris, you may resume your examination.
Yes, Your Honor, thank you. Good morning again, sir.
Morning, sir.
All right, I think the last thing that we left with was, I think I was getting ready to have you identify a couple of swabs.
Yes, sir.
So if I may approach the witness, Your Honor.
You may.
Yes, sir. I'm going to show you what has been marked as State's Exhibits 232 and 233. We'll start with 232 first. Can you tell us what State's Exhibit 232 is?
State's Exhibit 232 are swabs that I obtained from the green-colored vest jacket from the marker number 1 in the photographs from the lower left region of the red stain on the clothing.
Court's permission, I'd ask to publish State's Exhibit 114. It's already been admitted.
Permission is granted.
Is this on the two screen thing? Right,
You
yeah.
can log that, Mr. Halpin. We'll get this fixed.
It's 'cause it's on the screen. You want this in the slideshow? Yes.
It's not showing the one on the screen. It's
All right, on State's Exhibit 114, Detective, can you show us where you took the swab that is contained in State's Exhibit 232?
So, this region here, and that's where I obtained the swabs from the red stain on that clothing item.
Okay. And then, with the court's permission, I'd ask you to go ahead and open State's Exhibit 232.
Permission is granted.
Okay.
All right, and what is what you're holding in State's Exhibit 232?
Again, these are sterile cotton swabs that are prepackaged and sealed. Upon swabbing the red staining, I broke the seal, applied 2 drops of distilled water to each cotton swab, swabbed the red staining, put it back in this container, and then put it in an envelope to be sent off and examined by BCI.
Okay. And then State's Exhibit 233. What is State's Exhibit 233?
State's Exhibit 233 is the same swabs as 232, but from a different area. It's from marker number 2, the red staining above the tear within the fabric of the same article of clothing.
And with the court's permission, I'd ask you to open State's Exhibit 233.
Permission is granted.
And 233, again, prepackaged sterile tip cotton swabs. I swabbed the red staining in this area, identified on this article of clothing as number 2, in the same manner as number 1. Distilled water on the cotton swabs, swab the red staining, put back into its prepackage, put in this envelope, and then sent off to BCI for further analysis.
And what, Detective, I know you testified a little bit about this yesterday, but if you could refresh some of the recollections of the jurors. What sort of training have you undergone in order to take swabs like this from items of evidence that you just described?
So I've actually taken an online training that was presented by the Ohio Attorney General's Office and by BCI with their clear instructions of how to properly collect and swab samples such as these according to the policies and procedures. So I'm following the policies and procedures that BCI would employ at their crime lab, but I'm doing it so with the instruction from them, from the training I received here in-house at our headquarters.
Okay. And then, if I can approach the witness.
You may.
Or at least the area of the witness. So you said you took a swab from this area right here.
Yes, sir.
Okay. And then the other one is from this area right here.
Yes, sir.
Is there a particular reason, or why did you pick those two areas?
I had actually collected swabs from all 5 identifiers on the front of the clothing, and I had taken the sterile scraping of the dry substance on the back of the clothing. When coordinating with BCI about what they felt was best to initially submit, they wanted me to just submit the swabs from identifier number 1 as State's Exhibit 232 and swabs from identifier number 2, State's Exhibit 233, along with submitting the entire article of clothing. So that was their recommendation.
Okay, so it wasn't necessarily your decision. It was sort of a collective effort of many individuals in order to determine which swabs to send up there?
Yes, sir.
Okay. And then when swabs are taken from items of evidence, like we see in State's Exhibit 114, what do you do with the swabs?
I package them sterilely and submit them online through a portal to BCI, and
Okay.
it is transported up to BCI.
I would assume that, I'm sorry, I cut you off, right?
It's hand delivered.
Okay. And I assume once those items are taken, once those swabs are taken from the item it's contained in State's Exhibit 114, I assume those swabs are kept at the Hamilton Police Department, like in a property room?
Yes, sir, they are.
Okay. And again, that property room is secure, only certain people would have access to the property room?
Yes, sir. I don't even have access to the property room, so I turn it over to another individual who securely has access.
And then the items would be taken to BCI by, I believe it's a rotation of different detectives. A detective each week would take any items up to BCI that need to be taken?
Yes, it is hand delivered by one of us to maintain that chain of custody.
Okay. And with the court's permission, if I can display State's Exhibit 132. I think it's already been admitted.
No, permission is granted.
All right, so what are we looking at here in State's Exhibit 132, Detective?
After I collected swabs from each of the identifiers on the clothing, I then applied Blue Star in the same manner as I did in the sink in the bathroom at 1270 Parish Avenue to this article of clothing. Again, it appeared to me that the red staining on the article of clothing resembled that of blood. I applied Blue Star to see if I would get the same reaction as I would have in the sink and get the same chemiluminescent reaction as an indication for the potential presence or likelihood of blood being present. When I applied Blue Star to identifier number 1 here, that was the reaction that I received, that there was a high likelihood that the red staining on the article of clothing was blood. I also applied it to be able to show the contrast between the stain and the color of the green jacket. It was kind of hard to see in its natural state. So this highlights the difference in location of where I obtained the swabs as well.
Okay. And you would have taken the swabs first
Correct.
and then applied the Blue Star?
Yes.
Okay. State's Exhibit 133. What are we looking at here, Detective?
It is the same application of Blue Star, but it is on identifier number 2. I apologize, you can't see the identifier number 2 as clearly as number 1, but that is because the clothing item had folded when I was spraying it. But again, this is where I took swabs prior to the application of Blue Star and got the same reaction as I observed in number 1.
134.
This is identifier number 3 on the same clothing item. Again, with the application of Blue Star, I received the same chemiluminescent reaction, indicating that there was a high likelihood of blood being present from the area of where I obtained the swabs.
And then 135.
Identifier number 4, again, same reaction of Blue Star from the area where I collected the swabs from this particular location on the same clothing item.
And then 136.
Number 5, again, collected swabs from this general area, administered Blue Star afterwards. We've seen the same reaction for the high likelihood of presence of blood.
And then 137.
137 is the rear of the clothing item behind the left armpit. This was not a swab. Again, number 6 was a red stain, a substance that had dried and flaked. And so I took a sterile scalpel. Again, it's prepackaged like you would the cotton swabs. And I was able to scrape that off into a druggist fold paper, package that to an envelope, much like the ones for States Exhibit 232 and 233. Once that was collected, I still applied Blue Star, got the same chemiluminescent reaction for the high likelihood that blood was present.
And if I may approach the witness, Your Honor.
You may.
And Detective, what I would ask the court's permission, and I believe you've already identified State Exhibit 211, but I'll have you take out 211, please. And I know some of the tags have fallen off.
Yes.
So with the court's permission, if I can have the detective step down, and I would ask him to point on the actual exhibit itself, where region number 1, 2, 3, 4, 5, and 6 are.
Permission is granted.
So again, a lot of the identifiers have fallen off because I manipulated it, BCI has manipulated it, they've done their own analysis, it got sent back to us, we did another reanalysis of some areas. Stage 1, still present in the lower left region of this general location. 2, again, the general location of the cut mark. 3, as you can see, is still attached. It is right here on the chest pocket with the zipper. 4 is over here, lower right region. 5 was upper right region. And then if you flip around to 6, on the rear, the left armpit, right here where I'm indicating with my index finger, is where number 6 I covered from.
Thank you, Detective. If I may approach the witness, Your Honor.
You may.
And Detective, I'll hand you what's marked as State's Exhibit 218. I guess if you would, Detective, can you tell us what is in State's Exhibit 218, the first bag I gave you?
You want me to remove it from the bag?
Yes, please.
States Exhibit 218 is a dark colored gray button-up shirt. It was recovered on the second search warrant conducted on the residence. However, it was located during the first search warrant on the residence, but we did not know its interpretive value. We did not know it was evidence
Okay.
until the second search warrant on the residence where we recovered it.
Okay. And if you hold up State's Exhibit 218 with the court's permission.
Permission is granted.
It's a short sleeve, button-up Dickies gray shirt.
Thank you, Detective. And I'll probably be asking you to hold that here in a second. If I can direct you to the exhibit book. I'm going to ask you to look at State's Exhibits 138 through 146.
Okay. Yeah. Okay.
And generally speaking, what are we looking at in State's Exhibits 138 through 146?
States Exhibit 138 through 146 are photographs that I collected of the same shirt that I just showed before you, where I identified numerous evidence of red staining on this clothing item. I did not identify all because there were too many, but there were numerous where I was able to locate on this gray shirt.
All right, in State's Exhibit 138 through 146, are all those photos that you took?
Yes, they are.
Okay. Are those photos true, fair, and accurate as to your visual observations you were making of this gray shirt when you took the photos?
Yes, sir, they are.
Your Honor, I would ask that 138 through 146 be admitted and permission to publish.
Any objection?
No objection.
All right, they'll be admitted and they may be published.
All right, what are we looking at in State's Exhibit 138?
States Exhibit 138 is the gray shirt. And you can see that's just a photograph of it in its natural state.
And I know that you and I have talked about this before. I know when looking at the photo, the shirt kind of looks green, doesn't it?
It does, yes. And that could be because of the lighting that we have at the department.
Okay, but the picture that we're looking at in State's Exhibit 138 is in fact the shirt that is on the floor behind you, on the ground behind you, which is State's Exhibit 218.
Yes, sir, it is. It's the same shirt.
Okay, and I guess with the court's permission, if you'd like to stand up and show the different tags. So now there's a tag, there's a tag towards the bottom of the shirt there.
Permission is granted.
You can see,
If you'd like to stand in front of the shirt, please.
inside the collar, at the bottom of the shirt, with the same manufacturer identifiers.
Okay. And inside the collar there is also Dickies and,
There is
let's say Dickies and Flex.
Dickies Flex.
Okay. Thank you, Detective.
Yes, sir.
I'll get the tag from off there. All right, State's Exhibit 139. What are we looking at here in State's Exhibit 139?
This is the same shirt, but just generally, these are the locations where I identified what appeared to be blood stains, or red stains, if you will, on the front of the shirt. It is not all of them. It is just what was most apparent.
All right. State's Exhibit 140.
It's a close-up photograph. Same. It's showing identifiers 1, 2, 3, 4, 5 on the right-hand side. Or sorry, that would be the right-hand side in the photo, but it's the left side of the shirt. And then 19, 20, and 21 on the right-hand side of the shirt, but it's the left-hand side when viewing photographs.
State's Exhibit 141.
This is the upper portion of the shirt with also the left sleeve. You can see number 5 there in the lower portion of the photograph connecting the two images. Again, it's just another picture of the different identifiers that I had marked on the shirt.
State's Exhibit 142.
And this is showing the right sleeve and the identifiers that I marked there that appear to resemble that of red staining or blood.
The right sleeve with the left side of the
Photograph. Yes, it is. Yeah, you have to flip it in your mind.
All right, 143.
So these are close-up photographs of certain markers that I identified, number 2, 3, and 5. You can see the red staining in more detail.
States Exhibit 144.
And this is the right sleeve. Well, yes, the right sleeve, but in the photograph it looks like it's on the left side, where you have identifiers number 13 and 14 that were marked.
States Exhibit 145.
This is the back of the shirt, as is in its natural state.
And 146.
And this is where I identified just generally 3 locations of where that red staining appeared to be. As you can see now from the back, the right sleeve is on the correct side of the screen, it's on the right side. And then the left side over there, identifier, this one would be on the left side on the shirt.
And if I may approach the witness, Your Honor.
You may.
I'm going to hand you what has been marked States Exhibit 234 and 235. And what is States Exhibit 234?
States Exhibit 234 are swabs of the red staining that I collected from identifier number 3 on the front of this same shirt within the lower left edge.
And then States Exhibit 235.
And 235 are blood swabs taken from identifier number 14, which was the right sleeve of the shirt on the front portion.
All right, so in States Exhibit 140 that's on the screen behind you,
Yes, sir.
worded swab which is contained in States Exhibit 234, where did that come from?
From this location, identifier number 3.
So left side of the shirt with right side on the States Exhibit.
Correct.
Okay. And then where did swab 235 come from?
235 is going to be in a different States Exhibit photograph because it's on the right sleeve.
Which one you want? I'm sorry.
Probably 142, probably.
Yes. So States Exhibit 142, I have 13 and 14 on the right sleeve, but 14 specifically was this location here. Swabs of red staining that are contained within States Exhibit 235.
All right, and I assume that, or actually, again, explain to ladies and gentlemen of the jury here, what it is you did to take the swabs that are contained in States Exhibit 234 and 235. Explain how it is again that you did that.
Yes, so it's done in the same process as the swabs from the green vest. I collected them individually and separately. So States Exhibit 234 was collected, again, with prepackaged sterile cotton swabs, where distilled water was applied to the cotton swabs. I swabbed that area of staining, collecting it, putting it back in its prepackaged container, putting it in an envelope to send to BCI, and 235 was collected in the same manner, but from a different and separate region. It was collected from number 14 on the shirt.
And I assume that this would have been done at a different time than the jacket to make sure that there was no cross-contamination that was done.
Yes, absolutely. I believe everything was collected and swabbed on the same day. However, the jacket was swabbed and collected first, repackaged, I changed PPE, I reapplied PPE, gloves, and then handled the shirt separately away from the green vest, so there was no cross-contamination issue.
And what is PPE?
Personal protection equipment, gloves, goggles, masks.
Okay. And then with the court's permission, I'd ask the detective be allowed to step down with State's Exhibit 218, and I'd ask him to demonstrate on the actual exhibit, since probably several of the flags have fallen off, on the actual exhibit itself, where State's Exhibit 234, where that swab came from, and State's Exhibit 235.
Permission is granted.
So some of the stickers that are in place on the shirt have been moved, so the stickers that you can see, don't think that that's where they are. Whatever's in the photograph, that's where they are. These things get jostled around, as you can see, once it's fell. So, State's Exhibit 234, very faint, but you can see here, as it wraps around the left side of the shirt, which would be kind of the side where you have the seam. That's where that swab was collected for that State's Exhibit. And on the front here, number 14 was right here on the right sleeve of the shirt. In different shapes. Different. Number 13 was up here, number 14 was down here, towards the cup.
Great, thank you, detectives. And again, how was it decided that those would be the two swabs, swab 234, or swab that's in State's Exhibit 234 and the swab contained in State's Exhibit 235? How was that decision arrived at to send, or to swab those areas and or to send that up to the lab?
Again, I spoke with the analysts and scientists at BCI. I gave them the pictures and documentation of this shirt, and it was their determination that
Okay, sustained.
In consultation with BCI, is that why it is that you sent up those particular swabs?
yes, sir, it is.
All right. I think you have the book, you have the books in front of you. If you would please flip to State's Exhibits 158 through 166.
Okay.
And generally speaking, what is it that we're looking at in State's Exhibits 158 through 166?
So these series of State's exhibits were conducted after BCI had performed their analysis. Okay? And there's a particular reason why I say that, and we'll get to that. But these are photographs that I collected of the green vest here in State's Exhibit 158, which we will more closely view the tear in the green vest jacket.
All right, so generally speaking, these are, again, photos of the green vest jacket?
Yes.
Okay. Are those photos that you took
Yes, they are.
true, fair, and accurate depictions of what it is that you were looking at when these photographs were taken?
Yes, sir.
Okay. Now I'd ask that 158 through 166 be admitted and permission to publish.
Any objection?
No objection.
Okay, they'll be admitted and they may be published.
All right. And Detective, what is it that we're looking at here in State's Exhibit 158?
State's Exhibit 158 is the green vest jacket. It's just kind of like an overview of the tear next to identifier number 2.
If you would, so in these photographs, we're going to be looking at the tear that's in the vest, is that correct?
Yes, sir.
And if you wouldn't mind, go ahead and circle the tear it is that you're visually seeing in State's Exhibit 158. State's Exhibit 159.
So this is a close-up photograph of the tear. Now, in order to be able to take this photograph and represent it as best as I could as the fabric naturally lays and be able to see the uniqueness of that tear, I had to insert a piece of printer paper between the front and the back of the clothing item so you could actually see what that tear looked like as it laid flat. Otherwise, it would blend in with the background of the vest through the tear. You wouldn't see it as well.
And these photographs were taken well after these items were sent off to the lab for testing, and they were brought back to the Hamilton Police Department?
Yes, after the department and the prosecutor's office had spoke, we had decided that there was no more analysis to be performed by BCI, and that we were given permission to handle said items in this manner.
State's Exhibit 160.
So, State's Exhibit 160.
And let me stop you there, Detective, if I may approach the witness.
You may.
Yes.
I believe we looked at this yesterday, but State's Exhibit 215, again, what is State's Exhibit 215?
State's Exhibit 215 is the Swiss Army knife, or multi-tool knife, that was recovered from the residence.
Okay. And what is it that we're looking at in State's Exhibit 160 then?
I was asked to see if there was any correlation between the first blade attachment, where the blade was broken in some manner, and see if it correlated in any way or resembled in any way the tear that was observed on the green vest jacket.
Okay. And that's why it is you took a particular photograph?
Correct.
Okay. State's Exhibit 161.
Again, this is just another angle of how this uniqueness of the defect of the blade could have some similarities within the tear within that clothing.
162.
So again, with permission to handle these items in this manner, I inserted the knife between the front of the green vest jacket and the rear to be able to show maybe how the uniqueness of the blade defect could have caused this tear in this jacket, and is lined up as so.
State's Exhibit 163.
That is the orientation in which I took the photograph as observed in State's Exhibit 162, the one you just saw before. So that's how it was oriented and aligned as best as possible.
State's Exhibit 164.
So, State's Exhibit 164, again, with permission to handle said items of evidence, we aligned the gray shirt inside of the green vest as one would normally wear it to see if there were any correlations as to how it was aligned on someone's body if being worn together.
State's Exhibit 165.
And as you can see, I have then aligned the blade again to kind of demonstrate that uniqueness of the tear in the green vest jacket with the gray shirt inserted between.
And then 166.
And as an overall view of all the items combined with the blade itself having been inserted between the clothing items to kind of show the edge of the blade as having cut through the green vest.
All right, thank you, Detective. And then you have the exhibit book in front of you. I'd ask you to look at State's Exhibits 167 through 176.
Okay.
And generally speaking, what are we looking at in State's Exhibits 167 through 176?
These are photographs of the deceased victim's shirt where multiple tears were observed. And again, I was asked to see if there were any similarities with the multi-tool and specifically with the first blade attachment with the defected blade to see if anything lined up.
Again, are those photographs that you took
Yes, they are.
true, fair, and accurate depictions of what it is that you were looking at?
Yes, sir.
I'd ask the 167 through 176 be admitted and permission to publish.
Any objection?
No objection.
Okay. All right, they'll be admitted and they may be published.
I thought that's what
You may.
All right, what are we looking at here in State's Exhibits? This has already been admitted, 210.
State's Exhibit 210 is the deceased victim's shirt.
Okay.
As observed in the photograph above.
Right. So then what are we looking at in State's Exhibit 167?
That is the victim's shirt laid out flat as best as possible. It's the front of it.
State's Exhibit 168.
State's Exhibit 168 is a tear within the victim's shirt. Again, I was asked to see if there were any similarities between any of the tears in the victim's shirt with that unique first blade attachment of the multi-tool or Swiss Army knife.
State's Exhibit 169.
So that is a close-up view of one of the tears. I identified it as tear number 1 in the photograph, as State's Exhibit 168 depicted. This is a close-up photograph of this.
State's Exhibit 170.
This is with that multi-tool and the first blade attachment has the piece that's missing from the blade aligned with the tear in this fabric.
State's Exhibit 171.
This is a second tear. I identified as tear number 2 within the victim's shirt.
All right, and if I can approach the
You may.
If you're able to, Detective, in State's Exhibit 210, can you show us on the actual shirt itself, State's Exhibit 210, where that photograph is taken of?
Yes.
And with the court's permission, I ask the detective to be able to step down and show the jury.
Permission is granted.
Front of the victim's shirt.
If you need help, let me know.
photograph from this tear right here that I'm identifying. You can see my thumb, that specific one is number 2.
Is that the bottom left part of the shirt?
It is. It is.
You can go and step down to make sure all the jurors are able to see that.
Again, I had to insert a piece of printer paper in the front and the back of the shirt so you can better visualize the layout of the tear. When that's like flat.
And State's Exhibit 172.
It's a close-up photograph of the tear identified as number 2 in the previous exhibit.
State's Exhibit 173.
And this is how it was aligned when that first blade attachment with the piece missing in the multi tool appeared.
State's Exhibit 174.
This is tear number 4. That's on the victim's shirt.
And with the court's permission, Detective, are you able to show on the shirt where exhibit number 4, the arrow is on the shirt?
Give me a minute, I have to look through them all.
If you're not too sure, I'll take it.
Yeah, I don't want to take up too much of the court's time. It is fairly difficult to relocate. Oh, no, I have located it. Identifier number 4 is actually a pair. Be on the left side of the shirt. Here's a pointing with my thumb. So it's not necessarily on the front of the shirt. It's more towards the left side. Like the oblique or the waist would be. Again, to view it as best as possible, insert a piece of brown paper so you can see it in contrast with the background color of the center.
Thank you, Detective. State's Exhibit 175.
Again, this is the tear identified as number 4 in the previous exhibit, but with the same blade attachment kind of aligned above the tear in the fabric.
And State's Exhibit 176.
And the same tear identified as number 4, but with the blade attachment not aligned above, but over top of the tear in the fabric.
All right, thank you, Detective. And if I may approach the witness stand.
You may.
I think we're done with this stuff. So we can- think I neglected to ask you, going back to States Exhibit 234 and 235, I believe you identified those as swabs that you took from the gray shirt. With the court's permission, if I can ask you to first open States Exhibit 234.
Permission is granted.
Okay, 234, State's Exhibit, again. Prepackaged sterile swabs, cotton swabs, that were taken from region number 3 of the gray shirt. Okay, so that was kind of like the lower left portion of the gray shirt. Again, I applied a couple drops of distilled water to each swab, rubbed the red staining, put the cotton swabs back in its original packaging, and prepackaged it in an envelope to be sent to BCI.
And then States Exhibit 235, with the court's permission, I'd ask you to open 235.
Permission is granted.
And State's Exhibit 235. Same process of collection of the red staining as State's Exhibit 234. Prepackaged cotton swabs, distilled water applied to each swab, collected from the red staining of region number 14, which would have been the portion of the right sleeve on the front near the cuff. That was then put back in its original packaging, put into an envelope, and sent to BCI.
And likewise with the other two swabs, 232 and 233, those would have been kept at the Hamilton Police Department in the property room.
Yes, sir.
And again, only certain people would have access to that property.
Yes, sir.
And would have been taken up to BCI for testing.
Yes, sir.
Okay. And I think the ladies and gentlemen of the jury have heard a little bit about this, but Detective, were you assigned to a breaking, entering / burglary type offense that allegedly occurred at 1270 Parish Avenue on, I believe the date would have been October 6th of 2022?
Yes, I was.
Okay. Tell us how it is that you were assigned that particular case.
The defendant, Toby Madden, had made a offense report to Officer Bryant that I had been assigned for follow-up.
And what do you mean by follow-up?
I was assigned to reach out to Mr. Madden to kind of identify if there were any alleged suspects involved with the breaking and entering of the residence at 1270 Parish Avenue.
Okay. And what methods did you use or how did you attempt to make contact with Toby Madden as a follow-up?
Yes, so on the offense report that P.O. Bryant had filed, he had gathered.
Objection, can we have a sidebar?
Yes.
Thank you, Judge. I believe my question was, what methods or how did you try to make contact with Toby Madden?
So using the information from the report, phone number, address, I attempted to make contact by calling the listed phone number on the offense report to speak with Mr. Madden. I received no answer after calling twice. I then left my business card with my name, identifying that I was a detective with the City of Hamilton Police Department at the residence
Of 1270 Parish?
of 1270 Parish. The report, though, indicated an incorrect address for Mr. Madden. Said he resided at 250 Brookwood Avenue, which is not a good address for the defendant. The offense report was made for 1270 Parish Avenue. That's where I responded to in an attempt to speak with Mr. Madden and leaving my card. After having left my card, I still never received a call or contact from Mr. Madden himself, and I made the case inactive until further, until he made attempts to reach out to me.
If I can have probably 2 or 3 moments, Your Honor.
Yes, sir.
Give me 1 second, Mr. Miller. I believe that's all the questions I had, Your Honor. Thank you.
Thank you. Cross-examination.
Good morning, Detective.
Good morning, sir.
I want to talk to you with this, the alleged burglary incident you just spoke of. Is there a chance you didn't have the correct number when trying to contact Mr. Madden?
To be honest with you, whatever number I was given was the one I attempted to make contact with. I received no contact. That's why I made a personal appearance to drop my card in case the number was wrong.
Okay.
He could contact me with the correct number.
Sure. But my original question is there a chance you had the wrong number?
Yes, the phone number could have been documented incorrectly by the reporting officer.
The reporting officer on that was Taylor Bryan, correct?
Yes, sir.
And did you review his report before you came into court today?
Yes, I've reviewed that report.
And were you, at the time, were you a detective assigned to that specific burglary that occurred 5 days before?
Yes, I was.
Is it your understanding that Officer Bryan responded to the scene
Yes, he did.
and took photos?
Yes, sir.
And does his report indicate that there was damage to the back door?
Yes, it does.
Did you have any contact with anybody else at 1270 Parish, such as Rochelle?
No, I did not.
And you never spoke or saw Mr. Madden in relation to the burglary 5 days before?
No, sir.
Did you yourself go out to 1270 Parish and look at the property or the door at all?
I didn't. No, I don't. I try to make contact with residents there before going to the back of the residence, make my appearance known that, hey, I'm law enforcement. I'm not somebody just wandering about in the backyard. So I did not go to the rear of the residence and inspect the damage as reported.
Okay.
I just went to the residence to try and make contact with a homeowner or a resident there.
Sure. And Detective, you can't do every single thing possible on a case. Sometimes you have to rely on reporting officers or patrolmen to do certain things for you and give you this evidence for you to follow up on if you need to. Is that kind of fair?
Yes, sir.
Okay. I want to start with regards to the incident that ends up happening 5 days later, the knife, if the state wouldn't mind, since they're connected to the overhead, if you could put 150 up for me, please. Yeah. Detective, where did this knife come from within the parish residence?
It was located within the deceased victim's black backpack.
To your knowledge, was that black backpack, was it zipped up or buttoned up in any way?
I can't recall if it was zipped up or secured in any way.
Okay. Now, you testified that you observed this knife and you thought that there may be some sort of residue or some sort of wiping on this. Is that what you testified to?
Yes.
Now, you've shown us the fluorescent blue star that you used on other things, the sink, we saw it on the vest. Why did you never use the blue star on this knife to see if there was presence for blood on this?
That's because, again, this was a critical piece of evidence. So you kind of have to weigh the results of some tests being performed versus what your results may be. Knowing that this was a critical piece of evidence that might have minimal but sufficient important evidence to this case, I did not want to interrupt any DNA typing or analysis conducted by BCI by introducing Blue Star. Blue Star is a tool, it's a screening tool that you can use if you have sufficient evidence to use it. Here, I did not want to use it on such a critical piece of item of evidence. I just wanted to document it and submit it to the lab so they could do their own analysis in a more sterile environment.
I thought you testified, though, about Blue Star, that doesn't interrupt blood presence if it's there. I thought you said that to us.
Yes, you are right. It does not interrupt DNA typing or analysis. But again, you want to be able to have sufficient evidence to document the presence of blood. And on such a small knife blade, I don't want to apply Blue Star by overspraying and causing any DNA or blood that could have been present to fall off of the blade onto the sterile cardboard sheet below, and therefore losing that value of any evidence or potential evidence.
Okay. And the determination and maybe the conclusion of whether or not this blade has blood on it, that's for a DNA expert from BCI. Is that fair?
Yes, sir.
Were there any photos of this knife sent to the coroner?
If there were, I did not send them. I do not know.
Okay. That wasn't something you were involved with?
No, sir.
Do you well, you weren't recorded. The coroner referenced maybe possibly having a photo of a knife, but you're saying you weren't involved with that?
No, sir, I was not.
Did you attend the autopsy?
No, I did not.
Is it a common practice for someone within your department or your agency to attend the autopsy?
That depends upon the coroner. I guess it's a case by case. Sometimes we're allowed to attend, and sometimes we're not allowed to attend. But I did not attend.
To your knowledge, within the residence during these searches, were there any rags, towels, paper towels covered in blood recovered?
Not that were apparent or observed at the scene.
If the state could please pull up 77. Detective, this is one of the exhibits that you testified to, I believe it was yesterday. So the fluorescent that we're seeing here is indicating that there's blood that was present at some point. Is that fair?
Yes, it is a screening tool that gives you with a high degree of certainty that within the fluorescence that there is a high likelihood that blood is present.
You would agree with me that a sink is normally a place where you're going to wash your hands, correct?
That is correct.
And would you agree with me that if you had placed your hands on someone's body to perhaps give CPR, that you might end up with blood on your hands?
That is correct.
Are we able to tell from this fluorescent imaging whether someone washed their hands, but then they try to wipe any and everything away from the sink? Can we tell that from this image?
No, I don't see any apparent, if you're asking for like smears or wipes.
Because what I want to ask is if someone washed their hands in this sink and there's blood that falls in the sink, the water takes most of the blood down into the sink, but then someone wants to then take a rag, kind of wipe the bowl out, wipe the edges. Would this fluorescent that we see in States Exhibit 77, would it appear differently? Would it have swirls and motions like that for the blood?
I don't know if it would or not, to be honest with you. I just know how to detect its presence and recognize its appearance with the reaction. I don't know if it would show a smear.
Okay. Well, during your training with Blue Star, do they not cover something like that we can not only detect where blood has dropped, but we can also tell if someone has tried to wipe blood away? Is that not part of the training?
No, I'm sure you could be able to indicate if something has been wiped up. But specifically, no, that was not covered in any of the trainings that I was a part of.
All right. So you're telling me this picture is going to appear that way, whether the blood just was washed off hands, went down the sink, or if someone sat there and you literally used a towel to try to wipe everything up. You can't tell us if this picture would be different if someone tried to wipe all that away?
Oh, no, I'm sure it has the possibility of appearing different, yes.
Just a possibility? You don't think it would show swirls in this picture if someone used a towel?
I haven't been a part of any type of practical examination of that,
Okay.
but it is possible, yes.
You were involved with some of the searches at the property, correct?
Yes, I was there.
Were you involved with the search of Rochelle's car at the residence?
I did not search the victim's car.
Okay, so you would not be aware that rifles were found inside her car?
I was not a part of that search.
If the state wouldn't mind putting Exhibit 160 up. I want to talk to you about State's Exhibit 160. You were talking about the knife, and you were talking about some of the cuts within the vest. You've handled not only the vest and the knife. You've seen pictures of it. You were there. You've analyzed it. Would you agree with me that the vest and the knife are not new?
Are not new.
Meaning like they don't appear that they were recently purchased. They appear old. It's not like they were 1 week old, like they've just been bought.
I can't date the appearance of clothing when it was purchased versus if it's worn, and same thing with a knife.
Well, you can't tell does that knife appear to be new?
No, it doesn't appear to be brand new, but I'm not going to date it.
Does that appear to be rust on the knife?
Yeah, there could be indications of rust on the knife.
I mean, common knowledge, rust doesn't appear just overnight, right?
Right.
Takes a long time.
Again,
Just off
Yes.
your common everyday knowledge, with things you have in your house or you've been around, it takes a long time for rust to set in. Is that fair?
I would say it does take time for rust to set in.
Okay.
Yes.
When you're testifying about the cut in this vest, you said you had to put a piece of white paper underneath it to see it, correct?
Yes, because the background behind the cut is the same as the foreground, so it blends in. So yeah, I had to put a piece of paper in between so you can see the actual layout of the tear in the fabric.
So this, in order to find this cut and to look at it, you had to get pretty close to it. Is that fair?
Yes.
So if there was an angle from a Kroger video up on the ceiling, there's a chance it might not capture a cut that's in a vest. Is that fair?
That depends on the quality of the camera.
Well, true, you do agree with me that you need a piece of copy paper just to see the cut up close, right?
I think it highlights the difference. It contrasts it. You can see the cut. I could pull the article of item out, and the jury and everybody here would see the location of where the cut is. But to see it more thoroughly as what its design is, you need to highlight and contrast the differences between the front of the vest and the back of the vest. So
And we don't know how long that cut's been on that vest. Is that fair?
I don't have any way to date how long that cut's been there.
All right, that's all. Well, give me 1 second to confirm. Nothing further, Judge.
Okay, thank you. Any redirect?
Hold on.
Oh, okay.
Let's see here, if that's all right.
Sure.
Sir, did you do any kind of blue star illumination on the back door or near the back door?
No, I did not.
Was there any thing you did to try to observe or find out if there was any blood or other evidence at the back door?
The back door was locked with both doorknobs. I didn't have an indication that it had been opened at the time that I responded for the first search warrant on the day of the incident. So no, I did not.
But you were aware that 5 days before a burglary had been reported at that back door?
Yes.
Okay, nothing further.
Thank you. Redirect?
Again, it was just reported, there was no follow-up that was able to be done because you couldn't make contact with them.
That is correct.
Thank you, Judge.
Okay. Thank you, Detective. You may
Thank you,
step
Your Honor.
down. Is the state ready to call its next witness?
First of all, I believe Detective Trenton can be released from the state subpoena, although if Mr. Wilder would like him.
I'm sorry, Judge.
Detective Trenton would be recalled.
No.
Okay, I just want to release him from my subpoena. This might be good, I know it's a little early, this might be a good mid-morning break time because I think the next witness is going to be very late.
Okay. All right. Well, then let's go ahead. Thank you for that. Let's go ahead and take our break. It's about 9:40. We'll take 15 minutes and come back at 9:55. Please remember my recess instructions. Okay, the jurors have been excused from the courtroom. Before we take recess, I did give out jury instructions on Monday. As we're getting further along in the case, I'd like counsel to be prepared to have our first discussion about those at the conclusion of the state's case. I anticipate we'll have additional conversations, but just to get a start on that after we've at least heard the state's case. Other than that, is there anything from the state before we take our break?
I anticipate 2 more witnesses, Catherine Daly from BCI and Tanya Cook.
Thank you for that. Mr. Wilder?
Judge, are we still on the path of stopping at 12 like yesterday? Is that still
Yes, sir.
today?
Yes, sir.
And that includes anything, even with instructions or other things, we're dropping at 12?
Pretty close to. If we need just a few minutes, I can spare that, but any lengthy discussions we'll have to have tomorrow.
Okay.
And to be, well, no, nothing else, Your Honor.
Okay, all right. We'll be back then at 9:55. Thank you. First, Mr. Hahn and Detective Horton are present, and Mr. Wilder is present with Mr. Madden, who appears in person. Before the jury comes in, is there anything on behalf of the state of Ohio?
Just the next one is Catherine Daly does not wish to be found.
Very well. Anything else, Mr. Wilder?
Not at this time.
Okay. Okay, please be seated. Are there any violations of the court's recess instructions that anyone needs to report? Okay.
Yes, Your Honor, thank you. The state of Ohio would call Catherine Daly.
You may proceed.
Yes, Your Honor, thank you. Good morning.
Good morning.
Appreciate you being here. Would you please state your name for the record and spell your first and last name?
Yes, my name is Catherine Daly. First name is spelled Katharine. Last name Daly, Dailey.
And where are you currently employed?
I'm currently employed at the Ohio Bureau of Criminal Investigations. It's commonly referred to as BCI.
Okay. And what is BCI?
BCI is a law enforcement agency that will assist various other local law enforcement agencies in the investigation of crimes.
Okay. And is there a particular section of BCI that you work for?
Yes, I work in the laboratory section, specifically in the DNA section.
Okay. And what would be your job title at BCI?
I'm a forensic scientist.
Okay. And explain to the ladies and gentlemen of the jury what it means to be a forensic scientist.
A forensic scientist will look at items of evidence and collect samples for different types of analyses. In my case, collect samples for DNA analysis.
Okay. And in regards to your employment at BCI, being a forensic scientist in the DNA, actually, are you assigned to the DNA section?
Yes.
Okay. So then in regards to your employment being a forensic scientist in the DNA section, would you please describe to the ladies and gentlemen of the jury your education, your background and training in order to achieve such a position?
Yes, I have a Bachelor of Science degree. My degree was from Ohio University in Athens, Ohio. My major was in microbiology and my minor was in chemistry. And upon being hired at BCI, I underwent a year-long training program that included mock cases, lectures, online coursework through West Virginia State University, reading of forensic articles, journal articles, and lots of other things as well.
Okay. And how long have you been assigned to the DNA section at BCI?
I started in December of 2011, so I'm coming up on 13 years.
And on prior occasions, have you had the opportunity to conduct testing for DNA on different evidentiary items that have been submitted to BCI?
Yes, I have.
Okay. Do you have any idea how many times you run such tests?
Thousands of times.
And based on the thousands of times that you have conducted these types of tests, have you been able to make either a positive identification or I guess not an identification based on the testing experience you have run on evidentiary items submitted to your lab?
Yes, I have.
Okay. And if I use the phrase inclusions, what does that mean to you?
If someone is determined to be included in a DNA profile, that means that their DNA profile that we obtain from a known standard is consistent with that of a DNA profile obtained from an evidence item.
Okay. And if I use the phrase exclusion, what would that mean?
That means when making those two comparisons again between the known DNA standard and a DNA profile from an evidence item, at least one of the locations that we're looking at on that DNA profile is not consistent.
Okay. And have you previously been qualified as an expert in forensic science in the courts of law, first of all, here in the state of Ohio?
Yes,
How many times would you say that you have been?
it's upwards of 80 times.
Okay. And how about outside of the state of Ohio or including the federal system? Have you been called to testify as an expert as well in either other states or in the federal system?
In the federal system, yes.
Okay. How many times would you say you testified in the federal system?
One time that I can recall offhand.
Okay. I believe you told me it was here in the state of Ohio, it goes in the federal system?
Yes.
Okay. And, at this point, Your Honor, I would tender Ms. Daly as an expert in forensic science as it relates to DNA analysis.
Mr. Walker?
Judge, no vordare for this witness, no objection.
Very well. Witness will be so qualified.
Okay, thank you, Your Honor. Now, Ms. Daly, it's my understanding that you were asked to compare various items in the cases before this court in regards to DNA, is that correct?
Yes, that's correct.
And as part of the comparison process that I'm going to have you talk about, generally speaking, can you educate the ladies and gentlemen of the jury as to how it is evidence arrives at your laboratory here at BCI?
Yes, a local law enforcement agency will bring the evidence to our laboratory, and our evidence receiving staff will take in that evidence. It's assigned a unique case number, and each item of evidence is given a unique item number. These are tracked throughout the laboratory via barcodes, and they are placed in a secure vault until analysis is to be done on those items of evidence.
Can you say that? I don't think you need to continue. And if I may approach the young lady,
You may.
and hopefully there'll be an item that's on the screen behind you. This is going to be, just for purposes, this is going to be State's Exhibit 234. And just generally speaking, there's a kind of a light purplish type label that is on this particular exhibit. Can you just explain what it is that we're looking at here? Because I know you started talking about barcodes and things like that. So what is indicated on this particular exhibit?
So this purple barcode that is on this item will tell us what the BCI lab number associated with this item of evidence in this case is. It also tells us what the BCI item number is. At the top, it says item 15. It'll tell us what agency submitted that item, as well as their agency case number. And this is the barcode that would be used to track that evidence item throughout the laboratory. So for instance, when I would take this item of evidence into my custody, I also have a barcode that's assigned to me. So this would track it in the computer system, saying that it's in my custody.
Okay. And I would assume that each case would have a unique lab number, is that correct?
Yes, that's correct.
Okay, and then, but if there's multiple items that are submitted under the same lab number, that's how we get item number 1, 2, 3, 4, 5, all the way up to however many items BCI winds up getting?
That's correct.
Okay. And I would assume that when items are submitted to BCI, where would they be stored? Obviously prior to testing and then stored after testing.
They're secured in a evidence vault.
Okay. And again, I assume that not just anybody has access to the evidence vault. There's only certain people that would be allowed to go into the evidence vault.
Yes, it's limited access.
Okay. And I would assume that there has to be some sort of code punched in order to go into the vault to obtain items?
Yes, in order to obtain those items, you have to scan a card as well as punch in a specific number to the individual that's trying to get into the vault.
Okay. I'll go ahead and take this down for now. So how is it that you're able to ensure the integrity of evidences submitted to BCI and stored at BCI prior to testing?
So when the evidence items are received by the laboratory, the seal is checked on those items of evidence, as well as when that item of evidence is retrieved for analysis, the seal is also checked and noted. If any irregularities would be noticed, that would be put in the analysis notes.
Okay, thank you. And I believe that I have used the phrase DNA, and I'm sure everybody has heard from TVs and movies about DNA, but could you please educate ladies and gentlemen of the jury here as to what DNA is and what does DNA stand for?
Yes, DNA stands for deoxyribonucleic acid. It is the blueprint for our bodies, so it's going to tell us things like what color hair we might have or what color eyes we might have. We get half of our DNA from our mom and half from our dad, and it's unique to each individual except for in the case of identical twins, and it's also the same throughout our body. So if I were to take a swab from my cheek and a blood sample for myself, the DNA profile developed from each of those would be the same.
Now, in regards to DNA and what it is you just testified about, can DNA be used for comparison purposes to see if you can identify samples left behind on different objects to a certain individual?
Yes, it can.
Okay, if you would explain, ladies and gentlemen of the jury, how it is that you can do that.
So when we're making a DNA comparison, it's a 4-step process. The first step is going to be extraction, so we're going to take the DNA off of whatever item it was, whether it was a swab similar to a Q-tip, a cutting from an item, or a sample from like a cigarette butt. The second step that we're going to do then is quantification. We're going to determine how much DNA was obtained from that sample. Third step is called amplification, where we're going to make millions and millions of copies of certain regions of the DNA. And the fourth step is a real fancy word for taking a picture. It's called electrophoresis. So when I have those pictures at the end from both the evidence samples as well as the known reference standards, I can compare those two together and see if they are similar or dissimilar.
Okay. Now, in regards to DNA that may be left behind on a particular item, can you explain to ladies and gentlemen of the jury how that might happen?
Yes, DNA can be left behind on an item a number of different ways through bodily fluids, so saliva, urine, feces, semen, blood, or it could be left behind on an item by touching it. So my DNA would be expected to be on the binder that I brought with me today.
Okay. And if I use the phrase primary transfer, what does that mean to you?
That is the direct transfer of DNA to an item. So my DNA to my binder would be primary transfer.
Okay. And then what about secondary transfer?
Secondary transfer would be if someone came and picked up my binder other than myself. And if I were to try to swab their hands, they may or may not have my DNA on their hands because of that secondary transfer.
Now, in regards to internal lab protocols at BCI, what efforts are made to prevent cross-contamination or mixture of substances or samples that you may test?
So there are a number of different precautions that we take at the laboratory. Just to name a few, only one item of evidence is open at a time, so we're only looking at one item of evidence. We will also use a bleach solution to bleach down our worktops. We use brown paper to serve as a barrier between that bleached benchtop and the item of evidence. We also wear personal protective equipment, so gloves, masks, lab coats, just to name a few things.
So in essence, you're not going to be testing multiple items at a time, is that correct?
That's correct.
And I assume every time an item is tested, all surfaces and utensils will be cleaned before testing another sample?
Yes, absolutely.
And I assume that those are the protocols that BCI puts in place specifically for all employees to follow to make sure there isn't any sort of cross-contamination or anything like that.
Yes.
All right, so now in regards to DNA, what is the methodology that is used for determining if a particular item does have any DNA on it? And if it does, take us through the process, and I think you talked about it a little bit, of extracting that DNA from that item.
Yes. So initially, the item is received by a forensic biologist, and the forensic biologist is someone that's going to look at the item of evidence and collect any relevant samples. So they're going to look at potential bodily fluids, see if they can perform any testing to try to help determine what that bodily fluid might be. They'll collect samples from either bodily fluids or samples where someone might come into contact with an item. So shirts may be the way they wore it, so they'll swab the shoulder areas that come into contact with your skin. If it's something like a cigarette butt, they might take a cutting from the paper around the cigarette butt, and those samples are then placed into a tube and they are sent forward for the DNA analysis process. The DNA analysis process is that 4-step process that I mentioned earlier.
And go ahead, and just the different names of the process.
Yes. So first is extraction, second is quantification, then amplification, and then electrophoresis, where we get a picture of the DNA profile at the end.
So what is it that you're actually doing to the sample that you have in order to extract it?
We are applying certain chemicals to that sample to help remove the DNA off of whatever the substrate was that it was on, whether it was a swab or a piece of paper, and get it into the solution so that we can look at just the DNA itself.
All right, and we're going to get into this here probably very shortly, but with that process, with that process that you do with the items that they're going to be compared, there's probably two different phrases that we're going to talk about. So what is a known sample?
A known sample is a sample collected from an individual, so the origin is known. So we can use that DNA profile obtained from that item as a reference standard for comparison to any unknowns.
Okay. And then what's an unknown sample?
An unknown sample is a DNA profile that is obtained from evidence items within the case.
Okay. Like the items have been submitted to you guys?
Yes.
So then in regards to known samples that BCI would receive and unknown samples that BCI would receive, would you be able to compare those known samples to unknown samples to see if there is a match?
Yes.
And I assume when you make that type of comparison, whether they're known samples or unknown samples, do you generate or author a report to document what your findings are?
Yes.
And I assume that those reports are generated in the ordinary course of business by BCI?
Yes.
And those labs would be, or those lab reports would be kept in the ordinary course of business at BCI?
Yes.
And would you have done that in this particular case?
Yes, I did.
Okay. And when you compare DNA samples, or unknown samples to known samples, are you able to calculate a statistical frequency of a particular DNA profile?
Yes, we will calculate statistics on the evidence profile to show how rare or how common it is within the population.
Okay. And if I may approach the witness, Your Honor.
You may.
239 and 240. Ma'am, I'm handing you what's been marked as State's Exhibits 239 and 240. What are State's Exhibits 239 and 240?
These are copies of the reports that I authored in this case.
Okay. There's a true, fair, and accurate, is that, actually, let me ask you this, is that a copy of your report?
Yes,
Is that a true, fair, and accurate copy of the report that you have generated?
yes, it is.
Okay. And would that aid you in your testimony today?
Yes.
Okay. I know we have several things to go through. All right. If I may approach the witness, Your Honor. I'll have you identify what State's Exhibit 222 is, please.
State's Exhibit 222 is BCI item number 1, which is a DNA standard from Ms. Broussard.
And I think that is the only one that has not been opened.
You may.
And what is contained within State's Exhibit 222?
State's Exhibit 222 has a blood card from Ms. Broussard.
And I'm probably going to ask you to open that second envelope as well. And I'll take this from you. All right, so 222, if I can have it. Does that have a similar label that it is that you talked about before item number 1?
Yes, it does.
Okay, and we have the unique laboratory number 22-19832.
Correct.
I'll take that from you. And does this card that is inside, does that have any markings that you're familiar with or that you recognize?
Yes, it does.
Okay, what are the markings that you recognize?
The markings on this item have the BCI lab number, our item number, and the individual's initials and date of the individual who took the samples, as well as what date the samples were taken.
And then State's Exhibit 223.
State's Exhibit 223 is BCI item number 2, which is a DNA standard from Mr. Madden.
And if you would take out what's inside, and I will put them in blue. I didn't ask the court's permission before. I have permission to publish
Yes.
223.
Yes, granted.
And on the screen to your left, again, you recognize any of the numbers or markings on that?
Yes, this is the barcode for BCI item number 2 under BCI case number 22-19832.
And then what is contained within State's Exhibit 223?
There are 2 manila envelopes in here, and they have swabs within them.
Okay. And I believe this particular one. Would you mind taking that out, please? Do you recognize, are there any markings on that particular exhibit that you recognize?
Yes, on this exhibit, there are the same markings as before from the analyst who took the sample from this item.
And permission to publish, Your Honor.
Permission is granted.
Is that what we're looking at here on the screen?
Yes, it is.
All right, so speaking now about State's Exhibit 222, the blood card for Miss Broussard, and 223, the swabs from Toby Madden. These would be what are known as known samples, is that correct?
That's correct.
Okay. And are these two items, the 222 and 223, are those items that would have been tested by BCI?
Yes.
Okay, and let's start with 222, the blood card from Miss Broussard. Were you able to develop a DNA profile from that blood stain card?
Yes, I was.
Okay. And would that DNA profile, would that have been developed using the procedures outlined for the ladies and gentlemen here?
Yes.
Okay. And I guess if you would, now that we're talking about an actual sample, if you would, just go ahead and briefly explain to them the procedures again as to how you develop a DNA profile from them.
Yes. So in this instance, a tip of the swab would have been cut into a tube, and it would have been sent forward for the DNA analysis process. So it would have been undergone the extraction process, quantification, amplification, and electrophoresis. And then I would have used that picture of the DNA profile to make my comparisons to any profiles developed from evidence items.
And from State's Exhibit 222, the blood stain card, were you able to develop a DNA profile?
Yes, it was.
Okay. And if I use the wrong word, please correct me. And then in regards to State's Exhibit 223, the swab from individual identified as Toby Madden, were you able to develop a DNA profile from that particular item as well?
Yes.
And you would have used the same procedures that have now been outlined twice by you in order to generate a DNA profile?
That's correct.
Okay. And you were able to develop a DNA profile?
Yes.
Okay. So now that BCI has a DNA profile from Miss Broussard from the blood stain card, and now has a DNA profile from Toby Madden from the swab, are you now able to, I guess, compare those particular items, the blood stain from 222, the DNA profile, and the DNA profile from 223, are you able to compare that to unknown samples?
Yes.
Okay. And then by comparing those known samples to unknown samples, that's how you're able to either include or exclude.
That's correct.
Okay. And if I may approach the witness, Your Honor.
You may.
Now I'll hand you what's been marked as State's Exhibit 224. Can I have you identify what State's Exhibit 224 is?
State's Exhibit 224 is BCI item number 3, which is a envelope containing Miss Brusaw's left-hand fingernail clippings, as well as a fingernail clipper.
And if I may display State's Exhibit 224.
You may.
And again, do you recognize any of the labeling on State's Exhibit 224?
Yes, I recognize the BCI barcode as well as the individual's initials and date when they collected the sample from the item.
Okay. And much like the procedures that you use to develop a DNA profile from 222 and 223, would you have done something similar to State's Exhibit 224?
Yes,
And were you able to develop any sort of profiles on that?
yes,
Okay, and then let me ask you this. Were you able to come to a reasonable degree of scientific certainty? Do you have an opinion as to the DNA profile that was found in State's Exhibit 224?
yes.
Okay, what does that mean?
It is a mixture of DNA profiles, so that means there's more than one individual contributing to the DNA on the left-hand fingernail clipping, specifically a swabbing from a stain. The major DNA profile, or the individuals that is contributing a higher concentration or a higher amount of DNA, that DNA profile is consistent with Ms. Brusaw. Mr. Madden is not that major contributor, and the additional DNA on that item is not of sufficient quality for any comparisons.
And is there a statistical analysis or a statistical breakdown as to the frequency of Ms. Brusaw?
Yes, the DNA profile, the major DNA profile from the fingernail clipping, specifically the swabbing from the stain, the estimated frequency of occurrence of the major DNA profile is rarer than 1 in 1 trillion unrelated individuals. So that means I would have to test a number larger than 1 trillion individuals to expect to find this DNA profile again in the population.
And certainly there's not a trillion people in this world, are there?
They are not.
What does it mean to be a major contributor, and obviously what does it mean to not be a major contributor?
A major contributor is an individual that's contributing a higher concentration or a higher amount of DNA in the sample compared to any other contributor or contributors.
State's Exhibit 225. Have you identified that, please, ma'am?
State's Exhibit 225 is BCI item number 4, which is an envelope that contains Ms. Brusaw's left-hand fingernail scrapings.
Okay. And what is the difference between, if you know, fingernail clippings versus fingernail scrapings?
My understanding is in the method of collection, a scraping is what it sounds like, scraping underneath someone's nails, versus a clipping is similar to how you or I would clip our nails.
And I'll go and put this up here. State's Exhibit 225. Has that been admitted, Your Honor, officially?
No, identified but not
Okay. I guess I probably should have asked for 224 to be admitted to 225. And I'll go ahead and housekeeping matters 226 and 227.
Any objection?
No objection.
Okay, those will be admitted.
I apologize, Your Honor. And again, this has a similar label number.
Yes, it does.
Okay. Item number 4, similar lab number 22-19832.
Correct.
And was this item, although BCI received this item, did you analyze this item in any way?
No, this item was not examined.
Okay, is there a reason why it wasn't examined?
We looked at the fingernail clippings first.
Okay. And State's Exhibit 226. Can I have you identify State's Exhibit 226?
State's Exhibit 226 is BCI item number 5, which is a envelope containing Miss Broussard's right hand fingernail clippings and a fingernail clipper.
Okay. And again, item number 5 is similar label, similar lab number 2219832.
That's correct.
Okay. And did BCI, and did you do an analysis on State's Exhibit 226?
Yes.
Okay. And again, based on your training, education, experience, and your analyzation of State's Exhibit 226, do you have an opinion as to a reasonable degree of scientific certainty as to whose DNA is on this item?
Yes, they do.
And what is that?
The DNA profile from the right hand fingernail clippings, specifically a sample from the stain, is also a mixture of DNA profiles. The major profile is consistent with Miss Broussard. Toby Madden is not the major contributor, and the additional DNA on this item as well is not of sufficient quality for comparisons.
Okay. So we have no idea whose DNA that might be.
That's correct.
Could that still be Toby Madden's DNA?
I can't make any conclusions regarding who the contributor of that additional DNA is.
And then State's Exhibit 227. Do you recognize State's Exhibit 227?
Yes.
And what is State's Exhibit 227?
State's Exhibit 227 is BCI item number 6, which is an envelope containing Miss Broussard's right hand fingernail scrapings.
Okay. And were these analyzed by BCI?
They were not.
Similar reason why the left fingernail scrapings were not analyzed?
That's correct.
Gloves for this one. All right, State's Exhibit, for the record, 213. Do you recognize that particular exhibit?
Yes.
And how do you recognize that particular exhibit?
State's Exhibit 213 is BCI item number 7.
And I'll take that from you real briefly. And again, that has a similar barcode and label as the other ones do. Item number 7, 22-19832.
Yes.
If I can have you take out what is in State's Exhibit 213, please. And what sort of analysis was done on that particular exhibit?
This item was examined for the presence of possible blood. No blood was identified on this item, as well as 2 samples were taken for potential DNA analysis. However, those were not sent forward for DNA analysis.
Okay. But there was no blood that was found on that particular white food.
That's correct.
State's Exhibit 215. Do you recognize State's Exhibit 215?
Yes, I do.
And what is State's Exhibit 215?
State's Exhibit 215 is BCI item number 8.
And what is BCI item number 8?
BCI item number 8 is a knife multi-tool.
And if you would please open up State's Exhibit 215. And that also that's an item that was received by BCI.
Yes, it was.
And what sort of testing were you asked to do on Swiss Army knife with a multi-tool knife?
The multi-tool knife was looked at for the presence of potential bodily fluids, specifically for blood. Each area that was tested on this multi-tool knife was negative, so no blood was identified. There were 4 different swabbings taken from different areas of the knife.
So let me stop you there. With the court's permission, I'd ask for the witness to be able to step down and show the ladies and gentlemen of the jury where in particular the knife was swabbed.
Permission is granted.
Or if you prefer, if you want to do it on the overhead, either, whatever one is easiest for you.
Go over there.
Whichever is easier for you, yes.
Okay. So there were 4 areas of the knife that were swabbed. One of the swabbings was taken from this broken blade here. That is BCI item number 8.3. There was a swabbing of the handle, the red portion. That was BCI item number 8.2. There's a swabbing from the interior portion where this blade would have rested inside. And that is BCI item number 8.4. And then there's another blade that was also swabbed as BCI item number 8.1.
Okay. And all the opinions I'm about to ask you about, based upon your training, education, and experience, and within a reasonable degree of scientific certainty. Okay, is that fair?
Yes.
Okay. And what findings did you make on State's Exhibit 215, BCI item number 8, the Swiss Army knife for the multi-tool knife?
Yes. So BCI items number 8.1 and 8.3, the swabbing from the blade as well as the swabbing from the broken blade, the DNA profile obtained from those items was not of sufficient quality for comparison due to insufficient data. So simply put, there just wasn't enough DNA present to make any conclusions regarding that DNA profile. The DNA profile from the swabbing of the handle had the same conclusions. There was not enough DNA present to make any conclusions regarding the source of that DNA. And lastly, BCI item number 8.4, which is the swabbing from the interior knife from the broken blade where that blade sits deep down inside. The DNA profile from that sample was a mixture of DNA profiles. So again, more than one contributor is contributing to that DNA profile. The major DNA profile was consistent with Ms. Broussard. Mr. Madden is not the major DNA profile, and there is additional DNA present, but I cannot make any conclusions regarding who could be the source of that DNA as well.
Is that an unusual place to find DNA on the knife to you?
In my opinion, yes, somewhat, because as you saw, it's a very hard place to even get your fingers down into. However, if someone's handling the knife on a regular basis and opening and closing that piece, their DNA might be transferred there.
Exhibit, let me make sure. State's Exhibit 217, item number 9. If you wouldn't mind telling us what that is, ma'am.
Yes, BCI item number 9 is a shirt.
You can go ahead and take the shirt out if you would, please. And what sort of tests were conducted by BCI on this particular item?
BCI would have looked at the stains on the shirt and tested those to see if they would be presumptive positive for blood. And there was also a sample collected from the stain to be potentially sent forward for DNA analysis.
And what findings were there on the shirt?
The stain from the shirt was presumptive positive for blood. The sample that was collected was not sent forward for DNA analysis.
All right, State's Exhibit 231. What is State's Exhibit 231?
State's Exhibit 231 is BCI item number 10, which are swabs from a bathroom sink.
And likewise, this item, do you recognize the labeling on State's Exhibit 231?
Yes.
And what do you recognize?
It has the unique BCI barcode with the BCI item number and case number.
And the item that is contained within State Exhibit 231, do you recognize any of the markings on this as well?
Yes, this has the BCI item number as well as our unique case number, as well as the individual's initials and date of when the samples were collected.
Okay. And would an analysis have been done on this particular item, State's Exhibit 231?
Yes.
Okay. And were you able to identify any DNA profiles contained on State's Exhibit 231?
Yes. The
And
sample.
I assume that you would use the same procedures that you've outlined before?
Yes, I did.
And within, based upon your training, education, and experience, and based upon a reasonable degree of scientific certainty, what results did you conclude as to whose DNA is contained in State's Exhibit 231?
The sample was presumptive positive for blood. The DNA profile was a mixture of DNA profiles. The major DNA profile was consistent with Ms. Broussard. Mr. Madden cannot be, Mr. Madden is not the major contributor, and there's also additional DNA present that I cannot make any comparisons as or conclusions regarding who might have deposited that DNA.
So it could be Mr. Vans, it could not be Mr. Vans.
That's correct. I can't make any conclusions.
State's Exhibit 232. And what is State's Exhibit 232?
States Exhibit 232 is BCI item number 12, which are swabs from a green jacket, the left lower region.
And again, you recognize the label that's on States Exhibit 232?
Yes,
Item number 12, lab number 22-19832.
correct.
And the item is contained within States Exhibit 232. Do you recognize any of the markings on this?
Yes, again, it has the BCI lab number, item number, and initials and date from the individual that collected the samples.
And this is an item that you would have tested or analyzed as part of your duties with BCI?
Yes, that's correct.
And were you able to develop any, or able to ID, I'm sorry, were you able to develop any DNA profiles?
Yes,
All right, and then again, based upon your training, education, and experience, and with a reasonable degree of scientific certainty, what conclusions did you come to?
the DNA profile, the sample from that item was presumptive positive for blood. And the DNA profile obtained from that item was a mixture of two individuals. The major DNA profile is consistent with Ms. Broussard, and the minor DNA profile is consistent with Mr. Madden.
And what statistical probabilities did you come up with on those?
For the major DNA profile, the estimated frequency of occurrence of that major DNA profile is rarer than 1 in 1 trillion unrelated individuals. As far as the minor DNA profile, the estimated frequency of occurrence of the minor DNA profile is rarer than 1 in 1 trillion unrelated individuals.
Thank you. States Exhibit 233. What is States Exhibit 233?
States Exhibit 233 is BCI item number 13, which are swabs from a green jacket, the middle left region.
Okay. I assume you recognize the label that's on 233?
Yes,
Item number 13, lab number 22-19832.
that's correct.
And do you recognize any of the markings that are within States Exhibit 233?
Yes, this contains the similar markings of the BCI case number, item number, and initials of the individual who collected the samples.
And what sort of analysis was done on States Exhibit 233?
These samples were tested for the potential to have blood. They were presumptive positive for blood, and no DNA analysis was performed on these items.
In States Exhibits 234 and 235. Do you recognize those items?
Yes, I do.
And what are those items?
States Exhibit 234 is BCI item number 15, which is swabs from a gray button shirt, the lower left edge. States Exhibit 235 is BCI item number 16, which is swabs from a gray button shirt, right sleeve front.
And do you recognize the markings on States Exhibit 234?
Yes,
Again, item 15, lab number 22-19832.
yes,
And do you recognize the markings on what is contained within States Exhibit 234?
yes.
And what markings do you recognize?
Yes, there's the BCI case number, item number, as well as analyst initials.
And were you able to analyze State's Exhibit 234 and attempt to ID any DNA profiles?
Yes.
Okay. And based upon your training, education, and experience, within a reasonable degree of scientific certainty, what were your findings in regards to State's Exhibit 234?
The sample from the swabs was presumptive positive for blood. There was a mixture of DNA profiles on this item. The major profile is consistent with Ms. Broussard. Mr. Madden is not the major contributor, and there's also additional DNA present that I cannot make any conclusions on.
And what is the statistical analysis on State's Exhibit 234?
The estimated frequency of occurrence of the major DNA profile from the swabs from the gray button shirt lower left edge is rarer than 1 in 1 trillion unrelated individuals.
And you've already identified State's Exhibit 235. This is the one that needs to be opened. And this is
It's open.
Is it? Okay. Hold on, I missed it. I thought I'd opened it. On State's Exhibit 235, again, do you recognize any of the labels on this?
Yes, it has the BCI barcode on it.
Item number 16, lab number 2219832.
Correct.
And do you recognize any of the markings on what is contained within State's Exhibit 235?
Yes, it has the BCI lab number, item number, as well as analyst initials and date.
And were you able to analyze this particular item in regards to trying to identify any DNA profiles?
Yes,
And again, the same procedures that we've been talking about throughout your testimony?
yes.
Okay. And based upon your training, education, and experience to within a reasonable degree of scientific certainty, what were your conclusions?
The sample from the swabs from the gray button shirt, right sleeve front, they were presumptive positive for blood. There is a mixture of DNA present on that item. The major DNA profile is consistent with Ms. Broussard. Mr. Madden is not the major contributor, and there is also additional DNA present that I cannot make any conclusions regarding the contributors.
And then lastly, I believe there was one other item that you were asked to look at. State's Exhibit 216. And what are we looking at inside of State's Exhibit 216?
State's Exhibit 216 is BCI item number 17, which is a cigarette.
And was that an item that was tested by BCI?
Yes.
And based upon your training, education, and experience to within a reasonable degree of scientific certainty, what were your findings in regards to the cigarette?
There were 2 samples collected from the cigarette butt. One was a swabbing of the cigarette, and the second was a cutting from the paper that would have come into contact with someone's mouth if they were to smoke that cigarette. The swabbing from the cigarette butt was not sent forward for DNA analysis. However, the cutting was. The DNA profile from the cutting was consistent with Mr. Madden.
Was there a statistical probability on that one as well?
Yes, the estimated frequency of occurrence of that DNA profile from the cutting of the cigarette butt is rarer than 1 in 1 trillion unrelated individuals. And I should also mention that Ms. Broussard is excluded from that sample.
Ms. Daly, I think I had you identify States Exhibits 239 and 240. So States Exhibit 239, is that a lab report that you would have generated?
Yes,
And the date of that report would be December 1st of 2022?
that's correct.
Okay. And then it's my understanding that at a later point, the cigarette was delivered to your lab for testing, is that correct?
That's correct.
And that's what would have made you generate a second report, which would have been 240, is that correct?
That's correct.
Because that would have contained the findings from the cigarette, is that correct?
Yes.
Okay. And then explain the difference then between States Exhibit 239 and 240.
States Exhibit 239 would have included also items that were not examined, items that had DNA profiles that were developed that were not sufficient for comparison, and it also contained all of the bodily fluid testing within that report. Those are things that would not be carried forward to a second report.
Okay, so 240 is kind of a summary, and the date for the States Exhibit 240 is February 21st, 2024. So States Exhibit 240 would essentially contain a summary of 239 with the addition of the findings in regards to the cigarette.
Yes.
If I can have one more. I have another question,
All
Charlie.
right, thank you. Cross-examination.
Good morning, Ms. Daly.
Good morning.
I have a few questions for you. I want to, first, I know Mr. Burris went through everything with you, but I just want to kind of summarize if I can real quick with you. So you still have your report with you?
Yes.
So I want to start just to kind of go back over some of this, make sure I'm clear. So you analyzed the left-hand fingernail clippings of Rochelle, correct?
Yes.
And you were not able to make any conclusions of whether Toby Madden's DNA was within her left-hand fingernail clippings. Is that what you said?
He is not the major contributor, and I can't make any conclusions regarding the additional DNA that is on that item. So I can't include, exclude, or even call inconclusive.
Okay. And is the same, is that the same for her right-hand fingernail clippings as well?
Yes,
You were given 2 knives, correct?
that's correct.
One of the knives, it looks like item 7, no blood on that knife at all. Is that, am I reading that right?
The sample from the blade was tested for potential blood, and that was negative.
Did you get just a swab, or did you get the actual knife to look at?
We had the knife.
Okay. But one of the folding knife, no blood on, just to come back to that, right?
No blood on the blade.
Okay. And then the knife, your item 8 says knife, multi-tool. Is that what you stood in front of the jury with?
Yes.
There was no blood found on that, correct?
Yes. The samples that were tested for blood were the swabbing from the blade, the swabbing from the broken blade, as well as the interior knife from where the broken blade sits.
Right. Well, my question was, there was no blood detected on any of that, correct?
There was no blood identified on the samples I mentioned.
Okay. But you did say that looks like item 8.4, there was some of Rochelle's DNA on the interior knife from broken blade. Am I reading that correctly?
Yes, the major DNA profile was consistent with Ms. Broussard.
But what you found was not blood, or what kind of DNA was it?
The sample was negative when we did our presumptive test for blood. So as far as where that DNA came from, I can't conclusively say. It could have been from skin cells. It could have been from some other bodily fluid that wasn't tested.
Okay. That was what I wanted to know, because, and I'm probably not saying it right, but sometimes when we find DNA, it could be my blood, it could be my skin cells, it could be sweat, saliva. But you know, item 8.4 that you tested doesn't have blood.
Correct. There was no blood identified on that.
So if there's any DNA of Rochelle that's some other form, like skin cells or whatever, it's other than blood, is that fair?
Yes. I can't say what, though.
Right. Do you have any knowledge that this knife that was found was actually inside Rochelle's purse?
Yes, I did know that.
Okay. Because you said it would be unusual to find DNA on that part of the knife, but you would agree with me it would be unusual if it's a knife that's in someone's purse that they may use almost every day, correct?
I would be more expectant to find her DNA on like the exterior of the knife. So when we swab the handle, I would expect to find her DNA there. This is kind of just an odd place to find DNA since it's really far deep down inside and you can't theoretically like even stick your finger down in there.
Right. Have you ever used the multi-purpose tool? Have you ever used one of those?
Rarely.
When you saw it, do you see that there's little slivers in the top of each blade where you almost have to put your fingernail on to pull the blade up? Did you see that?
Yes.
So you're saying it would be uncommon if I'm opening that up, using my fingernail and my skin cells to pull a blade up, that it would be uncommon for my skin cells to be within the knife?
Not necessarily, like, I would expect your skin cells to be on that portion where you're contacting it and pulling it up. But this sample was taken from deep down in that group.
Okay. Have you yourself, have you ever used a knife to clean your fingernail beds out?
Not a knife, no.
I understand, but not everybody does things the same way. Would you agree with me on that?
That's true, yes.
Could you, I know you're not going to do that, but could you use the end of a knife such as what you looked at just to kind of clean your nail beds?
You could.
Right? Okay. Also, with regards to, I think it was the bright green shirt, you said that was positive for blood, but the steps weren't taken then to determine exactly whose blood that was. Is that fair?
Yes, that's correct.
Now, item 12 is a green jacket, and that's one of the pieces that you analyzed, and you said that Toby Madden was a minor DNA profile. Do you remember saying that?
Yes.
For item 12? Do we know what DNA that is that you found there? Is that skin cells? Is it sweat, saliva, blood? Do we know what that was?
The sample that was collected was presumptive positive for blood. I can't say whether his DNA profile was as a result of his skin cells being deposited on that item or if it was also his blood.
And the clothes you have on today, the clothes I have on, every time I touch my coat here, touch my tie, I'm depositing DNA and cells all over my clothing, correct?
That's correct.
So it's not unusual for a piece of clothing to have someone's own DNA on it, right?
Correct.
Okay. Judge, can I have a minute?
Sure.
No further questions, thank you.
Okay, you redirect.
think I just have one redirect
Okay.
question. There was some of the DNA that you tested that you were not able to make any conclusions as to whose DNA it is that correct?
That's correct.
And why would that be?
It could be for a couple reasons. The amount of DNA that was recovered from that item doesn't give a reliable enough DNA profile, so it doesn't meet our standards for comparison. It could have also been the quality of that DNA profile doesn't lend itself for comparison, or there could have been a number of individuals contributing to that DNA profile, making it also not sufficient for comparison.
Thank you, ma'am. Nothing else, Sean?
No recross.
Okay. All right, ma'am, you may sit down. Thank you.
Council Pro.
Sure. State may call its next witness.
Yes, Your Honor. The state will call Tanya Cook. If I may have a second. And my conversations with this witness, she does not wish to be recorded. I'm sorry, video.
Right. He left something on the projector.
Just need to do that a lot.
Proceed.
Good morning, ma'am. I appreciate you being here. Would you please state your name for the record and spell your first and last name?
Tanya Cook, T-O-N-I-A-C-O-O-K.
Okay. Do you know an individual by the name of Rochelle Broussel?
Yes,
How do you know Rochelle Broussel?
we were friends.
Okay. How long have you known Rochelle Broussel?
I knew her when we were younger, and then we played ball against each other, and then as we got older, because of Toby.
Okay. Are you a little nervous being here?
Just
Yeah.
Okay.
we need that microphone
Yes.
for the witness.
May I approach?
Yes, thank you.
We're having some difficulty hearing this, so.
Okay.
Let me, if I can ask that last question again, how is it that you know Rochelle Broussard?
We are friends.
How long have you guys been friends?
When we were younger, we played ball against each other, and then probably 5 years
Okay,
as adults.
all right. And you know an individual by the name of Toby Madden?
Yes,
You see Toby Madden in court today.
yes.
Would you please point to him and describe for the ladies and gentlemen of the jury what it is he's wearing?
A blue dress shirt
Okay.
with stripes.
Your Honor, that's a record to reflect the witness has identified the defendant, Toby Madden.
The record will so reflect.
Okay. And ma'am, I want to direct your attention back to around Christmas time of 2021. Did you have contact with Toby Madden around that time?
Yes,
Did you hear him say anything about Rochelle Broussard?
yes.
What did he say about Rochelle Broussard?
Objection.
Overruled.
You can answer, ma'am.
He said that he would cut her head off, put it in her mom's lap, so the whole family would have to suffer.
Thank you, Judge.
Cross-examination?
Ms. Cook, that was pretty quick. Are you Toby's cousin?
Yes.
What makes you think that? She's
Our
cousin?
grandmas are sisters.
What grandma, what's her names? What's her
My grandma Venerable and his grandma, they were Molly and Polly Venerable,
Okay.
or Croucher or something, I don't know the last name.
Did you get involved in this case where someone reached out to you, or did you call down the police department?
I called them.
This statement that you just say you heard, you said he was going to cut off her head and put it in his mother's lap?
Not
Or her
his
mother's
mother's, her mother's, that's before she passed away.
Okay. Who was around when he said that?
My daughter, my husband.
Who-
He
what-
said it over and over again. It wasn't just one time, it was over and over again.
When you say over and over again, you talking about just that day?
No, just different days.
Okay. So I'm assuming you called the police, right?
When he said that,
Yeah.
no, I did not.
You said he said this in the presence of your daughter. What is her name?
Haley Cook,
And you said it was in the presence of your husband?
yes.
What's his name?
Chris Cook, Warren Cook,
Where were you at when this was said?
at my house.
What were you guys doing?
Toby would sell clothes and shoes, and
When he was selling clothes and shoes inside your house?
he would bring them in his truck, and I would buy shoes from him or clothes, whatever.
Okay, so when I asked you what you were doing that day when he said this, you're buying clothes and shoes from him?
Yeah, it's depending on what day it was. Like,
Well, I'm
like I
asking-
said, he has
I'm
said
asking
it
you about
over
the day
and
that
over
he made
again.
the statement. What were you doing that day that he made this statement?
I don't know, we were maybe sitting on the couch. I don't know exactly. We were talking, sitting there.
You remember what day it was?
No,
Day of the week?
no, because he said it quite frequent. It was either he was going to stab her to death or cut her head off and put it in her mom's lap.
Where was he at inside your house when he said this?
It would be like right next to me on the couch.
All right, so he was inside your house?
Yes.
correct? And your husband was there?
Yes.
Were you drinking that day?
I don't drink or do drugs.
But your husband does though, right?
Yes.
Was he drinking or using drugs that day?
I don't know.
Well, how long have you been married to him?
22 years.
You can't tell us whether or not your husband's drunk after 22 years of being with him or on drugs?
He possibly was on drugs that day.
Did you ever take Toby to the hospital to see Rochelle's mom?
No,
Never?
never,
Did you ever take Toby anywhere to go see Rochelle's mother?
never.
Okay. Did you ever see Toby around her mother? Were you ever able to observe the two of them together?
No,
Did you ever see at your house Rochelle hit Toby with a stick?
what, it was a thing that you put up underneath the doorknob to keep people from coming in. He had come to the house, Rochelle was there, and I could tell by his knock that it was him. I was like, that's Toby, Rochelle. And so she got up and answered the door, and he had the stick, and he hit her with it.
Oh, he hit her?
Yep.
Did she ever hit him with it?
She took it back she got it from him and hit him with it.
If Steve would put up Exhibit 66, please.
I'm sorry.
I'm sorry, State's Exhibit 66.
Sorry.
If you wouldn't mind. Since you're connected, my computer's not.
I was just talking to Mr. Holmes.
Can you see, is there a screen in front of you that has that, ma'am?
Yeah.
Does that look like a stick that Rochelle would have hit Toby with?
No,
It doesn't?
no, it would have bothered
Yes,
me. It was like silver.
What color is this object?
I can't tell the color of that. That's not it.
You said this thing, whatever this, that Rochelle used to hit Toby, was it metal?
Yes.
And you said it went under a door?
It was to help secure your door in your house. You stick it underneath your door. But Toby was the one that came and hit her with it first.
Right, but you're not denying that she then grabbed it and hit him, correct?
No, I'm not denying that. She did.
They had a really hot and cold relationship, didn't they?
Well, I mean, she was defending herself.
Is that a yes or no? Did they
Hot
have a
and
hot and
cold
cold
relationship? Yeah, she was trying to get away from him, so it wouldn't be hot and cold anymore.
I understand that, and I'm not trying to disrespect that she's passed. I'm going by what you saw between these two, because the reality is, on the day that she is stabbed, you don't know what happened inside
No, I
that
do
house,
not.
do you?
No, I
But
do
you
not.
do know that they have a rocky relationship, don't you?
Yes.
And you do know that she hit him with the stick, whether he used it first or she used it first. You've seen her hit him with the stick
Yeah.
that goes under a door.
Yes.
Did you ever go as far as to tell the police that Toby pulled a gun on her?
No, I did not.
You didn't do that? Judge, can I have a second?
Sure.
No further questions.
Anything else?
There are, thank you.
Okay, ma'am, you may step down. Thank you.
The council for.
Yes, please.
On behalf of the state of Ohio, I believe Ms. Cook is released from the state's.
Very well. Okay, ladies and gentlemen, it's the court's understanding that the state has presented its last witness to you. So at this time, we need to take care of some business outside of your hearing. So I'm going to go ahead and release you a little bit early today so that we can take care of that. We'll come back at 9 o'clock tomorrow morning and proceed from there, okay? But please remember my recess instructions. Okay, please be seated. So the jurors have been excused from the courtroom, and at this time, would you like to take out these exhibits?
Yes, Your Honor.
Okay.
So I believe State's Exhibits 1 through I think 1 through 206 have all already been admitted.
And that's what my recollection is as well. However, there is no Exhibit 177, is that correct?
Correct.
Okay, so that takes us to 207, and go from there.
So, Your Honor, I believe the coroner's report is a self-authenticated document. It is certified. I think it comes in that way without any testimony.
Any objection?
Hold on one second.
Okay.
I was just catching up,
Sure.
make sure I didn't have. Yeah, you're talking about 207?
Yes.
Yeah, that's fine.
Okay, so that'll be admitted. And then I have 208, 209, 210, and 211 being admitted, 212 being identified but not admitted. That is the wallet.
Yeah, I am asking for its admission and/or photographs one way or the other. I know it's the wallet. I think there's a driver's license and stuff like that. So whatever the court's preference is, I can probably just.
You said are there photos of it?
No, I said we could either
Oh,
introduce that as an exhibit or we could take photos of it. It's going to be 212.
I'm assuming your ID's probably expired. Your driver's license? Yeah. You can send the wallet back. I was just making sure there's.
Okay, well, there's a dollar bill as well. A couple dollar bills.
No, it's fine. That can go back.
All right, so we'll admit that.
For like social security stuff, nothing.
All right. Yeah.
We'll do that. Issue date 95. Expires 2/17/2022.
That's fine. The wallet
All
can
right,
go back.
we'll admit that. And then I have 213 as being admitted, 214 as being identified but not admitted. That is the black book bag.
I'd ask for its admission now. And probably,
Any objections to the book bag?
No.
Okay, that'll be
if I
admitted.
asked your bailiff, I've gone through it, but if the bailiff would like to go through and make sure there's, I don't believe there's anything in here that's harmful or anything, but
If you would do that, Mr. Halcom. Okay. All right. So then the next, I have 215, 216, 217, and 218 is being admitted, 219 and 220 being identified but not admitted. That would be the gray hat and the Kroger bag.
I'd ask for this to be admitted.
No objection.
Okay, those will be admitted. And then it appears there is no Exhibit 221.
Correct.
Okay. So 222 I have as being identified but not admitted.
I ask for it to be admitted.
No objection.
Okay, that'll be admitted. And then I have 223, 24, 224, 225, 226, 227 is being admitted. And I do not have 228, 229, or 230 being identified or admitted.
Correct. There will be no exhibits there.
Okay.
What were those again? I'm sorry.
228, 229, and 230.
Okay. Got
All
it.
right, and then we've got 231, I have 231 as being admitted, and 232, 233, 234, and 235 as being identified but not admitted.
I ask to be admitted, Your Honor.
No objection.
Okay, those will be admitted. And then 236, I do not have a record of that being identified or admitted.
Correct.
Okay. I've got 237 and 238 as being admitted, 239 and 240 as being identified but not admitted.
I ask that they be admitted.
No objection.
Those will be admitted. I have 241 is admitted, 242 and 243 is being identified but not admitted.
I ask that they be admitted.
No objection.
Those will be admitted. And then I have 244, 245, 246, 247, 248, 249, and 250 is all being admitted.
Yes, Your Honor.
Okay, are there any other exhibits that we have not addressed?
Nothing other than what we discussed, no other exhibits other than what we discussed in site plan.
So with those exhibits being admitted, is the state going to have any other evidence?
The state has no other witnesses to present, no other evidence to submit, and the state would rest.
Very well. And of course, we'll let you do that in front of the jury tomorrow.
Yes, Your Honor.
Okay, now that the state has rested, Mr. Wilder, is there anything you'd like to put on the record?
Judge, at this time, we would make a Rule 29 motion for acquittal on all charges. I just argue that the state, even construing evidence in the light most favorable to them, have not provided sufficient evidence on all the elements of all the charges presented. Thank you, just
Thank
as
you.
honorable.
Anything that the state wishes to put on the
I
record?
believe that we have put sufficient evidence forward to warrant the case go to the trial effect.
All right. All right, well, the court has carefully listened to the evidence, and considering Rule 29 and the appropriate standard in that rule, the court is going to respectfully deny the motion. Okay, anything else that anyone would like to take up today before I take up a few items?
Nick,
Not at this time, Judge. Obviously, I'm discussing with Mr. Madden his case and whether he's going to testify or not. And once that decision is made, that'll obviously be something that I'm not sure what this county does or you yourself, Your Honor, but that may have to go on the record.
Very well.
But nothing other than that.
All right, well, that brings me to the jury instructions that I wanted to discuss with you. And in those instructions, we have started out by saying that Mr. Madden would not testify, but certainly we will amend that if, in fact, he chooses to exercise his right to testify. So I'll have that language prepared to go either way based upon what happens with the case as we proceed. Other than that, Mr. Burris, Mr. Hahn, do either of you have any comments, corrections, or requests to the draft jury instructions that I have provided?
I don't believe so at this time, Your Honor. We don't know what.
Sure, and I understand we would probably have to conference again, but I just want to have them in the best position possible so that they're easy for us to modify and alter as we proceed. Did you have anything that you wanted to change or add, Mr. Wilder?
Judge, I don't see anything with what's printed out here. However, based on some of the testimony, there is a potential that we may be requesting an instruction on voluntary manslaughter. I
All
will
right.
certainly file something as a formal record, but other than what was printed out, I don't see anything in there at this point. But if anything additional like that instruction is requested, I will certainly file something and obviously bring it to the court's attention.
All right. Well, then I will leave them unchanged at this point, and if the defense chooses to present a case after that, we'll conference again and see if we need to make any other changes.
All right, thank you.
Okay. Anything else before we recess for the day?
I assume it would be the court's intention to try and get this, this case to the jury by sometime tomorrow. We'll stay as late as we're going to stay.
If we are still presenting evidence or doing closing arguments, or if we're not finished with those things, I would anticipate asking the jurors if they would like to stay or not. If we're in deliberations, likewise, I will ask them if they wish to stay. So I'm largely going to leave it up to the jurors. So if you would be prepared to stay past business hours, if that's how they choose to proceed.
Yes, Your Honor.
Okay. Anything else?
I don't have anything right now.
All right. All right. We'll see you all tomorrow morning at 9 o'clock. Thank you.
Yes, Your Honor, thank you.
Thank you.
Part of the court record in the Baldwin case is there is one filed in the recent response. Mr. Nika's file.
But it's not in this case.
Yes, I can't find it readily, Your Honor.
Okay, so I'll strike that part. Go ahead, Ms. Morrissey.
Um, I will say, though, that this is an issue that Mr. Bowles raised in his initial motion for a new trial. I responded to it. I stand by my response. I summarized the conversation that I had with Ms. Johnson, and Ms. Johnson indicated that she wanted the case dismissed out of issues that she was concerned about for self-preservation. I disagreed with that. I don't think self-preservation is a reason that you dismiss a case. There's a legal analysis that has to be done in order for the court to consider disqualifying a prosecutor. Mr. Bowles hasn't cited to any of those cases, and he hasn't put that legal analysis in any of his motions. So I would ask the court certainly not to consider granting that without a motion that actually addresses the law and the facts as they relate to the law. This isn't something that you just randomly ask for. The legal analysis has to be conducted, and it hasn't been conducted here. So having said that, I responded to Mr. Bowles's concerns about the veracity of my testimony. Quite frankly, I'm not sure that it's relevant to his motion for a new trial. But because it's something that he's put in his motion and it's something that he has argued, there was no meeting about these Teskey rounds. I did not attend a meeting. I did not see the rounds until July 12th. I did not see the doc report until I believe it was July 12th or July 11th. I'd have to check my email. Whenever I got it, and I provided it to the defense attorneys. I had no idea that there were 3 rounds that had the same characteristics as the live rounds from the set of Rust until July 12th. Mr. Bowles can complain all day long that he thinks that's not true. I'm telling you it's true. And how that ended up happening is actually quite clear, because what happened in this case is that Mr. Teskey took a photograph of the rounds that he had in his possession and he sent it to Seth Kinney. We ended up with that photograph. I've included that photograph in my response to Mr. Bowles's motion for a new trial. It does not show any ammunition that looks remotely similar to the live rounds that were found on the set of Rust. He went further than that. Mr. Teskey said, I looked at these rounds, I couldn't find any with silver primers. Okay, so at this point in time, the state, this is long before I ever came on the case, but the state understands at that point that the ammunition that he is in possession of does not look remotely similar to the live rounds on the set of Rust. That doesn't make them material. It's okay for us to say we're not going to collect those because he sent pictures and they're not material. Then we go ahead and we do his pretrial interview. And I decide maybe I should go ahead and collect those. So I make that statement to him during the pretrial interview. Mr. Bowles can argue all he wants that he was assuming that we were going to take him. He had no idea that we weren't going to collect him. I had an email exchange with him in January that's attached to my response where I explained to Mr. Bowles, I am not collecting that ammunition. If you want it collected and you want it tested, go ahead and do it and ask for a continuance of the trial. That is a conversation that took place over email and it is attached to my response. So Mr. Bowles understood we were not going to collect it. And it was during that email exchange that Mr. Bowles then provided more photos of the Teskey ammunition, and those photos matched exactly the photos that were provided to Mr. Kinney by Mr. Teskey, and they showed rounds that were completely dissimilar to the live rounds on the set of Rust. This is information that is coming from Mr. Teskey, and it's filtering through Mr. Bowles. So Mr. Bowles doesn't get to come to the court now and say, hey, they should have collected these. The information that he gave us caused us to reasonably believe that they were completely immaterial. We had no idea that any of those rounds matched the live rounds from the set of Rust. Mr. Bowles provided us a photograph in January, a month before the trial, for heaven's sakes, that showed that they were completely dissimilar. So then let's jump to the trial. This is where Mr. Bowles' argument completely fails. He wants to rely on the court's dismissal of the Baldwin case, but he can't rely on that, because what happened was these rounds were in the possession of his witness. He told his witness to bring them to court. He got to look at them. He told his witness, I'm not going to call you as a witness, and I'm not going to take these rounds. We're not going to touch any of this. I understand why he did it. Because, again, as I have said, sure, in a world of infinite possibilities, can you argue that these rounds somehow came on through Seth Kinney? I guess, but you can certainly you have a much stronger argument that this is how they came on through Ms. Gutierrez. Her father had these rounds that were exactly like the rounds that she brought on. So Mr. Bowles knew about this during trial. So when we're doing the legal analysis for whether or not Ms. Gutierrez gets a new trial, she does not get a new trial based on this ammunition that was in the possession of her father's good friend, and that she and her lawyer had during trial. The state did not have. She and her lawyer had them during trial and chose not to use them. That is exactly what happened. So the legal analysis, the 6 factors that this court has to look at when deciding to grant a new trial, the second one is that the newly discovered evidence has to be discovered after trial. That's not the case here. This evidence was discovered by Mr. Bowles during her trial when the state had no idea what those rounds were comprised of. He made the judgment call, hopefully after consulting with his client, not to call Mr. Teskey and not to use the rounds. They don't get to now come and say, we made a strategic error, so give us a new trial. That's not how this works. So the issue of the Teskey rounds with regard to Ms. Gutierrez's motion for a new trial, it is absolutely, it's not permitted under the law. It was not discovered after trial. Here's the other thing that the court needs to take into consideration. A motion for a new trial can be filed for almost any reason within 10 days of the conviction. Mr. Bowles is limited to a motion for a new trial based on newly discovered evidence beyond the 10 days. So Mr. Bowles, having seen those rounds for himself on the second to last day of trial, having infinitely more information about those rounds than I had, easily could have filed a motion for a new trial within the 10 days, but he chose not to do that. So he has given up, he has waived his right to use that in a motion for a new trial. Furthermore, I want to point out to the court, Mr. Bowles filed a lengthy motion for a new trial, and never once did he articulate or argue the legal standard that is required for a new trial. Never one time. And I'm glad that Ms. Gutierrez is listening to this, because the legal standard that he is required to meet was never mentioned one time during his motion. The state mentioned it in the state's response because these are the 6 factors that the defendant has to meet in order to get a new trial. So let's move on to the Kinney interview. Mr. Bowles outlined, I think, approximately 20 statements in that interview that he had specific concerns about. And he's absolutely right. I want you to know this was suppressed. The moment that I found out that this audio recording existed at the district attorney's office, I immediately provided this to Mr. Bowles. I couldn't believe that there was an audio recorded interview of this witness that had been sitting at the district attorney's office that had never been uploaded to the discovery server. The previous prosecutors were unaware of it. I was unaware of it. My team was unaware of it. It was absolutely a failure. There's no question about it. I immediately provided it to Mr. Bowles. But that's not the end of the analysis. The analysis is Mr. Bowles has to meet those 6 factors in order to get a new trial. So what Mr. Bowles did was he filed a motion and he outlined 20 statements, the vast majority of which were statements previously made by Mr. Kinney that were already in the possession of Mr. Bowles and Ms. Gutierrez. So then when we get to Mr. Bowles's reply, what we see in the reply is that the 20 statements have now basically been narrowed down to 5, because someone had to come and point out that Mr. Kinney had already talked about the fact that there were 325 rounds that were taken to Texas. He had already made all of those statements about Sarah Zachary being the boss. He'd already made all of these things. So Mr. Bowles filed this motion, having seemingly not reviewed any of the discovery that was in his possession with regard to Mr. Kinney's statements, so that he could file a motion that actually had the material issues related to the Kinney interview. So now we're down to the 5 issues that Mr. Bowles ends up relying on, because the other 15 turned out to be things that really were already in his possession, were already within his knowledge. So when we go through and we look at these, I'm sorry, there's I think he narrowed it down to 8. So where he is right now is he's asking the court to grant a new trial because the interview with Mr. Kinney talked about that there was a standard that Ms. Zachary was the boss and she's managing things, which allows the armorer to focus on guns. This came out during trial. Not only did it come out during trial, it was fully articulated in the text messages between Mr. Kinney, Ms. Zachary, and Ms. Gutierrez. Hannah has more experience on Westerns than Mr. Kinney did until 1883. Well, I would hope so, because Mr. Kinney is not an armorer. So the comparison between Ms. Gutierrez's experience and Mr. Kinney's experience has absolutely nothing to do, is completely immaterial with regard to this case. And importantly, the factors that this court is required to consider do not create a situation where Mr. Bowles gets a new trial because there's something out there that could be potentially impeaching. The law actually doesn't give him that with regard to a new trial. His third issue, prop masters who handle guns won't call out armorers to test bullets. I don't understand. I mean, I don't understand how that could even be remotely material. We had plenty of evidence from people who were on the set, who work on movie sets. Mr. Kinney does not, by the way. He doesn't work on movie sets. And we had an expert come in and say that armorers are supposed to test the bullets. So how is this material? The sheriffs confuse the replica guns with the real guns. What does that have to do with the elements of the offenses that Ms. Gutierrez was charged with? It has absolutely nothing to do with those. Mr. Kinney heard nothing but good things about Hannah on set, and all of the concerns about safety that came out later he hadn't heard about. Judge, that's all in the text messages that Mr. Bowles had. He had all of that. Mr. Kinney actually, there's an exchange between Mr. Kinney and Ms. Gutierrez where she talks about the director saying what a good job she was doing, and Mr. Kinney responds. All of that is in the text messages. This was always in Mr. Bowles's possession. Mr. Bowles didn't review it. He didn't use it during the trial. That was his decision. Sabotage could be anyone on set. Mr. Kinney doesn't work on movie sets, and he was never on the set of Rust. Okay, so this is his speculative opinion. It was also something that Mr. Bowles had the opportunity to fully explore at trial, and did in fact fully explore at trial. Because Ms. Gutierrez left the ammunition unattended, anyone could have messed with it. Yes, we went through all of that. Because these firearms were left unattended, yes, anyone could have messed with them. We knew all of that. All of that came out during trial. The idea that if the camera crew had gotten their hotels, would they have still felt unsafe? This is number 7 in Mr. Bowles's reply. This has absolutely no material value with regard to the case against Ms. Gutierrez in any way, shape, or form. That the assistant director and Alec Baldwin didn't give Hannah every ounce of support and she got pushed around. Well, this was Mr. Kinney's opinion, but you also have to keep in mind, Mr. Kinney was never on the set of Rust. Mr. Kinney never met Mr. Halls, the assistant director. He also never met Alec Baldwin. So this is a statement that he made that has absolutely no foundation, and also is completely immaterial to the case against Ms. Gutierrez. Now, we get into the issue of the third Hague report. And look, I understand that to a certain degree, the job of a defense attorney is to make things seem perhaps a little worse than they are because it helps their arguments. Nothing was intentionally buried. This case had a terabyte of discovery. There was new discovery coming in constantly. This was a report that I believed I had forwarded on to our staff to have it uploaded to the server. When I realized during the Baldwin preparation for trial that did not occur, I immediately I took full responsibility for it. Mr. Bowles points to the email where I took full responsibility for it as though I've done something wrong by taking responsibility for it. I believe that it had been forwarded on. I went back, I looked, it had not been. We did the best that we could to resolve it at that point in time. And listen, the problem with Mr. Bowles's argument with regard to the Hague report is twofold. First of all, the Hague report clearly says the microscopic marks on the tip of the sear did not affect the functionality of the gun. Furthermore, Mr. Hague has since learned exactly how the destructive testing of the gun was being done and has now come to the opinion that these microscopic marks were made by the testing at the FBI. So Mr. Bowles wants to say, Judge, it doesn't matter. The fact that the guy has changed his opinion after he got new evidence, that stuff shouldn't matter. Well, it most certainly does matter, because when you look at the 6 factors that this court has to consider when granting a new trial, is the probability that the result would be different if the new trial was granted. So if you have an expert who said, initially, I'm not exactly sure where these microscopic marks came from, but I don't think that they came from the FBI. Then he goes and he talks to the guy at the FBI, gets more information about how that testing was done, and the expert then says, okay, now that I've got this new information, I've changed my opinion. I think that they did come from the FBI. Well, that goes directly to the first prong of the 6 prongs, which is whether or not a new trial would result in an acquittal if the court were to grant the motion. It's not going to, because Mr. Haig got more information about the testing, modified his opinion, and the other thing is that Mr. Bowles hired, although I don't think he paid him, but he had his own firearms expert. Not only did he have his own firearms expert, he used an investigator in this case who purports to have a fair amount of expertise in firearms. So you've got basically 2 people who have expertise in firearms working for the defense, and you have the photos of the sear and the microscopic markings on the sear that were provided to the defense for their review. Not only did they have the photos, but the gun was sitting over in evidence. They can go, they can look at the gun, they can take the gun, they can test the gun, they can do any of those things, and they opted not to do any of them. Now, presumably, either the defense expert, Mr. Kuski, or the defense investigator was tasked with going through all of the photographs that Mr. Haig took. What Mr. Bowles has actually said in his reply is, oh my gosh, Judge, there were so many photographs. We can't be responsible for having to review all of those. They certainly can be. They needed to review each and every photograph. I know how long that takes because I did it myself. So the basis of the Haig opinion was always in the possession of the defense. And they seem to just basically ignore the fact that they had the photos, that they had their own expert, and they basically had their own expert come in and say, we agree with Mr. Haig, the gun worked fine. That was the reason that they called that expert, was just simply to say, we agree, the gun worked fine. They had everything that they needed. But listen, I'm not trying to take away from the fact that this was a report that should have been provided and wasn't provided. I have taken full responsibility for it. I will continue to take full responsibility for it. So I want the court to know I'm not trying to get around that. But one of the factors that this court has to consider is, would the newly discovered evidence have been discovered before trial by the exercise of due diligence? They had a photograph of it. They had a photograph of the markings on the sear, and not only was it a photograph, right next to it is a photograph of a sear without those markings. It was in the possession of the defense the entire time. So this easily could have been discovered by due diligence. That due diligence meaning simply go through the discovery that you have. Go through the discovery that you have. And you know, New Mexico is unlike so many other states, in fact, perhaps all states, because defense attorneys actually get to interview the state's witnesses. So that is the opportunity for the defense to exercise their due diligence to discover things. That's the whole point to the pretrial interviews. So in this case, what happened was, we had a pretrial interview scheduled of Mr. Haig. Mr. Bowles did not attend, because Mr. Bowles did not attend, I think, 95% of the pretrial interviews. So he opted not to attend. He left it to his investigator. His investigator conducted a 25-minute pretrial interview, and not a single question was asked by the defense investigator about any of the photographs that the Haigs took, they asked about the damage to the gun. Mr. Haig indicated there was damage to the gun. He further indicated that the sear was damaged. That came out in the pretrial interview. So when you look at the 6 factors that the court has to consider when granting a new trial, the defense doesn't get there. They simply do not get there. I further have some concerns for the record. So one of the issues that Mr. Bowles has made an issue in these motions, which is a little confusing to me, is the issue with regard to the standard of state v. Ware. So what he's arguing is that the ammunition that's in Teskey's possession, under Ware, the state had the obligation to go and collect, and by not collecting it, that resulted in a due process violation to his client. Here's the problem with that argument. I sat and went through every single New Mexico case related to Ware. I can give you the list, and for the record, because we have so many potential appellate issues, I'm going to tell you, Judge, not only did I look at State v. Ware, I looked at State v. Crone, which was provided by Mr. Bowles. I looked at State v. Kinney, State v. Torres, State v. Martinez, State v. Camden, State v. Rodriguez, State v. Bailon Escobedo, State v. Baca, State v. Garcia, State v. Kant, State v. Taylor, State v. Perkins. Those are the New Mexico cases that discuss the Ware standard. Every single one of these cases says that the obligation of the state has to do with collecting evidence from the crime scene, and they make it very, very specific. And Ware indicates this is very limited. The state is not required to scour the planet Earth for potentially exculpatory evidence. It is evidence that is from the crime scene. This is not evidence that was from the crime scene. This is evidence that was in the possession of a defense witness. Mr. Bowles knew in January that we weren't going to collect it. He knew that it had never been collected. He certainly did know that because he was in contact with Mr. Teskey. Mr. Bowles could have had that ammunition tested. I mean, the chain of custody was shot. There was never going to be any chain of custody with this anyway. This isn't something that was located at a crime scene and was taken into evidence. This is something that was sitting in a defense witness's garage. So Mr. Bowles could have had this tested. He opted not to have it tested. He could have had it tested. He could have had those test results compared with the test results of the FBI. And the best case scenario for the defendant is that would indicate that the same powder that was used in the ammunition that was in Teskey's possession is the same powder from the powder, or consistent rather, with the powder from the ammunition from the set of rust. And that exact same powder is used in millions and millions of rounds of ammunition everywhere. One of my concerns since this issue arose has been the fact that Mr. Teskey 2 times sent photos of the ammunition in his possession, twice, and never sent a photograph of a round with a silver primer. In addition to that, he indicated, I have looked at these rounds and there are none with silver primers. And then 2.5 years later, he shows up with ammunition that looks just like the ammunition from the set of rust. And again, you can buy this ammunition at any gun store. This isn't special. You can get it anywhere. You can get ammunition with these exact same characteristics at any gun store. So out of, to be thorough and complete, the Ware analysis doesn't match in this case. It absolutely is really irrelevant to this case because the defense had more access to this ammunition than the state did prior to Ms. Gutierrez's trial. Now, with regard to the Baldwin case, that's a completely separate issue because that is information that was in the state's possession prior to his trial. So there are real issues with regard to that disclosure. That's completely different. This case, Mr. Bowles had it in his hand. He had it in his hand during trial. And Mr. Teskey, I'm not making things up, Mr. Teskey told law enforcement on video, I offered this to Mr. Bowles and he said he didn't want it. That's what Teskey says on the video. So, you know, Mr. Bowles acts like I'm pulling this out of thin air. I'm not. That's what Teskey said. He said Bowles didn't want it. And again, Judge, I understand why he didn't. So I also want to articulate, because I think that this is an issue that Mr. Bowles is raising and is arguing, specifically with regard to the reply that he filed. And let me be specific in his reply, if you'll give me just one moment. I'm just reviewing my notes here real quick. So with regard to Mr. Bowles's reply, he says, both parties, the defense and the state, knew that Teskey had ammunition from the same batch that Reed and Kenny took to Texas. I disagree with this statement insofar as it oversimplifies what happened. So both parties knew that Thel Reed possessed a variety of .45 caliber ammunition with a whole lot of different characteristics. That was proven by the photographs. It was proven by the ammunition that was taken from PDQ into the sheriff's department. So, but what there's no proof of, absolutely no proof at all, is that each type of ammunition that was in Mr. Reed's possession went to Texas and then went to New Mexico. So if Mr. Reed has 20 different types of .45 caliber ammunition, and it strikes me that he had about 20 different types of .45 caliber ammunition, there's absolutely no evidence or testimony that the ammunition that is silver primer starline brass with that particular projectile shape ever went to Texas, let alone ever came to New Mexico. So when we say it came from the same batch, I guess my concern is, what do we mean by batch? If there is evidence, actual evidence, that these specific rounds went from Arizona to Texas to New Mexico, I've never heard it. Mr. Bowles actually went so far in his reply to say that the Teskey evidence was deliberately hidden from him. The Teskey evidence wasn't deliberately hidden from Mr. Bowles. It was provided to him by his own witness. He could have had it tested at any point in time. I would respectfully ask the court to deny Mr. Bowles's motion, and if Mr. Bowles wants to file a motion to disqualify me, he can file that motion. That is a separate motion. There is case law on that motion. I would ask the court to deny this motion. Thank you.
Thank you, Ms. Morrissey. Reply, Mr. Bowles.
Yes, Your Honor, thank you. Your Honor, I want to start off by telling the court several initial points. The Teskey evidence that was deliberately withheld was the Teskey supplemental report. We still have Brady rights on appeal. That was not given to us, the March 6th report. So Ms. Morrissey misconstrued that. She also misconstrued the idea that I didn't want the evidence. What I told Mr. Teskey was that I didn't want to be in the chain of custody of those rounds. And I was actually a good idea that I did not, because Ms. Morrissey's now accusing Mr. Teskey, in essence, of planning silver primer rounds in that group of rounds. She just made that argument. Now, Mr. Teskey originally, way back when this case started, did a cursory search through the rounds and did not locate any silver primer rounds. He thereafter didn't touch them, and that's where the text came from very early on. He didn't touch them. Miss Morrissey was saying she's going to come get them. That's what she said at the interview. So by the time we had the email exchange, which, by the way, Your Honor, she didn't email me. I emailed Miss Morrissey trying to figure out where this was at. And then she responded, I'm not going to get these rounds. It was too late. This court had made clear, and I don't remember the exact date, but that we weren't going to continue the trial. There was not sufficient time at that point to test them. And we could not test them, Your Honor, because the FBI had the powder for the live rounds on set. We don't have an ability to match those unless they're tested at the FBI. So the state did suppress those. And we're not asking on the Ware standard for them to go to the ends of the earth, as Ms. Morrissey said. They knew the individual who had them. They knew this early on. And that, as the court put in paragraph 30 of the court's opinion from July 31st, there was a progressive trail established of how these rounds could have gotten to the rust set through Mr. Kinney. Now, Ms. Morrissey wants to denigrate that idea, but finally today she said, well, I guess in a wild speculation, you could say Mr. Kinney brought them. No, that's a real possibility. That's something the jury should have been able to consider, but they never wanted to acknowledge any possible defense theory, which is why they suppressed everything, because Ms. Morrissey didn't think it was relevant. With regard to the Hague report, Ms. Morrissey made extensive argument about how we should have divined these microscopic or very small damage to the trigger and sear through looking through thousands of pictures and having our experts somehow divine the opinion of Mr. Hague that this, or come to the same opinion as Mr. Hague. But what she's ignoring and trying to get this court to ignore is the failure to produce that report from the main state witness who was opining on whether the gun functioned correctly. And I just accepted that at trial because I accepted his answer that there was no modification that affected, and no modification other than the FBI testing, which that was the case in the pretrial interviews. That was the case at trial. Ms. Morrissey said pretrial interviews are where we can figure these things out. Well, we couldn't even figure out at trial because he didn't answer the question in a truthful manner. What he said was there is no other modification to that trigger or sear. Now that's false. And Ms. Morrissey wants to conveniently skip over that and the idea that we should have had this and it's no harm, no foul, even though we have abundant proof of false testimony, and she's admitted we didn't get the report. That's something we could have absolutely crossed on and used under 14-251 on this idea that the court pointed out in Mr. Baldwin's order on the negligence of third parties and the proximate cause argument. Your Honor, regarding the Seth Kinney statements, I did read it all. I boiled it down in the reply to the 8 most important, and that's why I wanted to get the court to consider. Ms. Morrissey tries to, again, run away from the idea that she suppressed something by characterizing as we had it all. Well, we didn't have it all, and we didn't have it specifically all from Seth Kinney's mouth. So that's not true, the arguments that were just made, and we could have crossed him on that, and he was an important state witness, as this court knows. Your Honor, with regard to the Teskey rounds, what Ms. Morrissey didn't address at all is not the new trial grounds, but we've asked for a dismissal under the court's inherent power. And the whole Teskey argument, and I've been open about it, I didn't see those till 2 days before the end of the trial. At that time, there was no way to do anything with them because they had been suppressed in essence by the state not getting them, Mr. Teskey not wanting to touch them. For the exact reason that Ms. Morrissey accused him today of planning rounds. That's the reason why he didn't do anything with them. But, Your Honor, the Teskey evidence and the court's opinion in Baldwin goes to the remedy of dismissal because the egregious nature of this prosecutorial misconduct in this case, specifically by Ms. Morrissey, her false testimony does a blow to the whole system of justice. It's not just to this case. As this court appropriately found and was warranted in Mr. Baldwin's trial, this affects the whole system. Why people respect the system, they voluntarily turn themselves into jail when a judge rules, is because they have respect and confidence and public trust. What Ms. Morrissey did in this case is she destroyed public trust across the board in the Rust prosecutions on a case that was watched by the nation and the world. A case being paid by the taxpayers, one of the biggest debacles, ethical misconduct, probably in the history of New Mexico. But this court appropriately dismissed that case to restore and maintain and uphold the integrity of our system. And so I'm asking the court to consider doing that in this case as well, because it's not fair and it's not right when the prosecutor doesn't play by the rules and it doesn't engage in fair play. That undermines our entire system.
All right, thank you for your presentations today on this particular motion. I will consider these arguments as well as the pleadings. I will issue an order. I plan to issue the order early next week. All right, but at least next week. All right, let's move on to the motion for immediate release.
Yes, Your Honor, and that really, I think, is predicated upon the court's ruling, whichever way the court would rule on the instant motion we just argued. So I'm open to suggestions of this court or counsel. Judge, I don't know if it's ripe until this court rules.
I think it's right. You've got section 3111(1)(c), and you've also got the case law.
Yes, Your Honor, and with that, I am asking for immediate release, and some of the same arguments we've already presented with regard to the Hague third report. Judge, this is on appeal. It's been remanded on a limited basis for this court to rule on the motion for new trial. I know that the state has responded that there are issues that Ms. Gutierrez-Reed has had with regard to statements she's made. But Your Honor, the fact of the matter is, while she was on pretrial release in this case, she didn't have any violations. She didn't go anywhere. She's not intending to flee. She's not intending to try to avoid prosecution. Your Honor, and I would submit that if or to avoid her obligations to this court, I would submit that she's not a danger. If this court were to enact conditions, she doesn't have firearms. She could be on house arrest or whatever conditions this court deems appropriate. While this case is pending, whatever decision this court makes early next week, that she be allowed to be released pending the appeal. One of the problems, Your Honor, is that the length of time of this appeal, if this case proceeds to appeal, is likely to take longer than her sentence. And that's just a fact of how the system proceeds. And so we're asking, with the issues we've raised, for this court to consider releasing her while this court considers this motion and the appeals court considers our arguments.
Ms. Morrissey.
Your Honor, the state objects to the release of Ms. Gutierrez. Mr. Bowles indicated that she didn't have any violations of her conditions of release. I think we didn't have any evidence of those violations that we could bring to the court, but we did discover when listening to Ms. Gutierrez's jail calls that she was in possession of alcohol during the trial. Discussed violating the court's order that she not possess firearms during her jail calls. And she has already signed a guilty plea to a felony in her other case. So Mr. Bowles' argument that she doesn't have any other criminal history I know that he argued that initially in his motion, and she has now since signed a guilty plea in that case. So I'm not trying to beat him up over that. When he made that assertion in his initial motion, it was accurate in terms of her convictions. It is no longer accurate. And based on those issues, we would ask the court to deny Mr. Bowles' request to release Ms. Gutierrez. And I will say that one of the things that has mystified me in terms of the way that Mr. Bowles is handling his appeal, he's filed more than one motion before Your Honor asking that the court release Ms. Gutierrez. I think this is the third such motion that I have responded to. I think the court has only heard two of them because one of them was never set for a hearing. But if Mr. Bowles has concerns about the fact that his appeal is going to take so long that essentially Ms. Gutierrez will have served her entire sentence by the time his appeal is over, I don't understand why he isn't addressing that with the Court of Appeals. I think that he can do that. I think that he should do that, and he should have already done it. So we would ask this court, based on everything that we've gone through this morning with regard to Ms. Gutierrez's motion for a new trial, the 6 factors that have to be met in order for that to be granted. I have never seen a case in the state of New Mexico where the district court dismissed a case post-conviction based on discovery issues, and I don't think that Mr. Bowles has pointed to such a case. So I don't know that asking the court to dismiss the case against Ms. Gutierrez based on the 2 issues that Mr. Bowles was unaware of during the trial is appropriate. The appropriate remedy is motion for new trial. He can't meet those 6 factors. So I remain confused as to if Mr. Bowles has concerns about the length of time of the appeal and how it relates to his client's sentence, file a motion asking for release before the Court of Appeals, because they have a better idea of how long their appeal is going to take than we do. But for some reason, he's not done that. So we would oppose Ms. Gutierrez's release. It sounds like the court's going to rule early next week. So certainly if the court rules that Ms. Gutierrez gets a new trial, the court can immediately release her. I'm not sure the court even needs to have a hearing on that. I think that's well within the court's power. But the state objects to it, for the record. Thank you.
Your Honor, just briefly. Yes, Your Honor, thank you. Just briefly. Your Honor, the reason why we are asking for dismissal in this case is that it is the most egregious case I have ever seen of prosecutorial misconduct. And there's always an instance where you have to ask a court for something you're compelled to do on behalf of your client, because there is no case I've ever seen that is this bad. Mr. Baldwin's lawyers wrote that in their response they recently filed. And this court appropriately dismissed that case. That's why we have asked for the dismissal remedy, because this case is so egregious. What happened? Lying, cheating, hiding evidence. Second, Your Honor, with regard to the release, we wanted to go through the chain of command. We wanted to address that with this court first. And then we will, depending on this court's ruling, we would go to the Court of Appeals next. But I wanted to respect the chain of command and respect this court's authority over the proceedings. And this court had previously ruled on those issues. So that's why we filed it. So, Your Honor, we would respectfully agree with Ms. Morrissey, if this court rules in our favor early next week, this court wouldn't have to have a hearing and could just release her.
All right, thank you, counsel. Again, I appreciate your presentations today, and I do appreciate your briefing. I'm going to consider your motions. I will address them in 2 separate orders. Your motion for release, immediate release under 5402, and then the order on discovery violations and inherent power, new trial and dismissal. All right. Thank you.
Thank you.
We are in recess.